Making sure it's working on my end. Okay, looks good. All right, well, let's get on the record. This is docket 30, switching numbers. It's the second time I've done this. All right, it's docket 9300 PLI 128. The investigation of the complaint of Wisconsin Power and Light Company against Forward Contractors LLC, referred to the commission pursuant to Wisconsin statute section 182.0175 sub 3 sub BR paragraph 2. So my name is Michael Newmark, the administrative law judge for the PSC. We're here on Zoom with the complainant, respondent, and commission staff in attendance. We've made the connection available to members of the public, and we're taking public comments here today as well. Just wanted to begin by looking at our participant list to see if there are any members of the public in attendance, and I do not see any. So we'll have no public comments at this point. I may pull the list of participants at the end of the hearing just to make sure that we didn't get any members of the public joining us at that time. We're also accepting written comments from the public. They are due Tuesday, July 30th. They can be filed by at the commission's website or mailed to us, and the details on doing that is on the notice of hearing. So just in terms of basic process here, these what we call the Diggers Hotline complaint cases, I'm assigned to take evidence and create the proposed final decision in the case. And then that decision is offered to parties for comment. And then once comments are collected from the parties, the entire package of the record goes up to the commission for its review, and then it makes the final decision, accepting the proposed decision or modifying it in some way, or rejecting it in some way. But so the process is I'll be issuing a preliminary decision first, then the commission will make the final decision. So in the interim, we'll also have an opportunity for the parties to file briefs in the case, and we can discuss that at the end, setting a schedule for that. We're transcribing the case, so there'll also be an opportunity to propose corrections to the transcript, and we'll discuss a process for that at the end as well. So that's kind of our basic, just so you have an understanding of kind of the basic parameters of our process. But today at the hearing, it's the opportunity to offer evidence. I'll receive that evidence if it's appropriate, and we'll allow witnesses to be cross-examined. So that's basically how we'll proceed in this part of the proceeding. First of all, though, let's get appearances from our parties and commission staff. Just going to display on the screen the service list, just in alphabetical order. We have Forward Contractors first. So who's in attendance on behalf of Forward Contractors?
My name is Mike Lalonde, Lalonde, and I'm the owner of Forward Contractors.
Okay, perfect. So the list you're seeing here, that's the list we'll use to serve documents, including the decisions that I render and the one that the commission comes up with at the end. Just want to make sure that we have the correct email address for you. Can you see it there?
I do see it there. I would like to change that to a different email if possible.
Sure, let's do that.
Actually, the email underneath my name, you have Forward Contractors LLC and an office at fwdcont.com. That's a general. You've been PSC has been sending everything to the Mike L at fwdcont, and I'd like to continue that.
Okay, so just to the Mike L.
Yeah.
Okay.
Yeah.
Okay, we'll do that. So that's where we'll send our official documents for you.
Okay, thank you.
Sure. All right, so next is Public Service Commission. Who's representing commission staff?
Sophia Rogers.
All right. And Alliant Energy, Wisconsin Power and Light Company, who's representing that?
Zach Ramirez, Your Honor.
All right, great. All right, I'm assuming no changes to the list for either the commission or WPL.
No, Your Honor.
All right, okay. So let's just return here. I'm just going to stop the screen share for a second here. So I just wanted to mention, we have a couple of preliminary issues here that kind of are slightly unexpected, but we'll want to power through those before we take our first witness. The first one, or really the first one, I just wanted to remind everyone or put them on notice that for our hearings, I don't allow any profanity. So I just wanted to make sure people are aware of that in terms of the hearing process. I find it disrespectful to the tribunal. If anyone does utter profanity at the hearing, I'll be forwarding them to the commission to initiate contempt of court proceedings under Wisconsin statute 785 sub 4. And I just wanted to give you this. Well, I won't bother with the screen share on that. So I just want to make sure. I know there's some issue with a proposed exhibit. It's exhibit WPL MES 1, which purports to be a written version of an alleged voicemail that Michael Lalonde left with Chad Kruger of Diggers Hotline, and it does contain a profanity. So I will not be accepting the document as it's been filed that has that profanity in it into the record. And we can discuss the exhibit and its contents, but we will not be using the language that's prohibited when we do that. So I want to make sure everyone's aware of that at the beginning. This exhibit does pose some challenges. So my understanding is that the complainant obtained the recording from Diggers Hotline, and that the recording was sent to the commission in its native format, an MP3 file, which was not accepted, cannot be accepted by the IRF system, our electronic filing system. We also typically do not allow media files into the record. So the record almost always is simply documentation that appears on PDF files, sometimes Excel files, but not media files. So the process we do use in case that a media file is necessary evidence for the record is to have that, if it's something like we're seeing here, a conversation, a short voicemail, could be transcribed by an official court reporter and certified by that court reporter. In order to be presented at hearing, any profanity that includes would have to be sanitized. And I think probably is understood. What I mean is that you'd use asterisks or dashes to incomplete any profane words so that the meaning would be conveyed, but not the actual language be presented. At that point, the document could be offered as a exhibit, but it would have to be authenticated. In this case, we're looking at an out-of-court statement by an adverse party. So potentially, this document could overcome hearsay objection. Not that hearsay necessarily applies here, but I think in administrative agency hearings, but it is a good test for veracity. So in order to have this particular conversation verified, I don't believe Chad Kruger is being made available, who is the other person who may have heard or known where the source of the alleged voicemail has originated. We do have Mike Lalonde available, who's the alleged person who spoke that voicemail. So potentially we could have that witness verify that the conversation existed and that the conversation is what's being purported by the exhibit. So I just wanted to say, as a preliminary matter, I think the information that's being conveyed by this exhibit is already in the record. I think if you look at the Diggers Hotline Enforcement Panel referral, it clearly says that, and I can put this on the screen, but it clearly says that the respondent does not want to participate, refused the education course, and asked the complaint be referred to the PSC's first sentence in the Diggers Hotline summary. So I think I could reject that exhibit simply on the basis of being duplicative on the record. There may be other aspects why the complainant wishes to offer this exhibit, but we'd have to get through all the other hurdles and barriers to have it actually received. So I can allow any comment from Wisconsin Power and Light on the any other grounds for accepting this document, but or once it does meet the standards of being acceptable, I could receive it. I could hear Wisconsin Power and Light's argument about that. At this point, though, I'm inclined just for the terms of administrative efficiency to avoid duplication, and really because it doesn't really speak to an item of a violation of Chapter 182, that it's not quite relevant or material. Although I think I would like to hear what the complainant has to say about that. So any comment from WPNL?
Yes. Yeah. Thank you, Your Honor. The purpose of it is that previously the commission's held that because it's given discretion in determining a forfeiture amount and is given wide discretion of up to $25,000 per incident, what the commission has previously written is, in determining the forfeiture amount, it must look at mitigating factors as well as aggravating factors. And the commission has previously written that aggravating factors are items which show on the part of an individual blatant disregard for the one call system, blatant disregard for its protocols, standards, and procedures. And Power and Light agrees with Your Honor that the Diggers Hotline complaint itself shows the fact that the educational course was refused, but the manner in which the excavator has responded to the offer of education, we believe that's shown in the email or shown in the voicemail, shows a blatant disregard for the one call system. And that's the purpose for offering it.
Okay. So yeah, before we move on, then any comment from the respondent, Mike Lalonde?
What am I responding to? That the alleged voicemail? I don't recall that, nor do I recall an offer of this class. This is 2 years ago, and this blatant disregard, nope, that is not correct. We call on hotlines. I think some things were taken out of context when we were talking about removing the stones. There is a provision in the Wisconsin administrative law that says that you can remove rigid pavements without a hotline.
Okay, I'm going to stop you right there. You're just getting into, we'll get to what happened on the day, but I just wanted to get your take on that voicemail. So
yeah.
So you don't recall making that statement? Is that what you're saying?
No, I don't recall. Nor do I don't remember talking to anyone from Diggers Hotline, to tell you the truth. So to answer your question on the voicemail, I'm not familiar with it. I don't recall it, and also the offer of education or training, I don't recall that. Nor do I have any documentation here of me receiving anything or me refuting anything in writing.
Okay. Any comment from commission staff?
Thank you, Your Honor. Commission staff would comment only that this investigation has been prolonged and made more difficult by a lack of cooperation from the respondent. We acknowledge there are evidentiary issues with the voicemail, but it does seem to be relevant. for the reasons stated by Wisconsin Power and Light.
Okay. Okay, well, if I can't get the conversation verified by Mr. Lalonde, and Mr. Kruger is not here to testify. So at this point, I don't think we can, because of failure to authenticate the conversation, I won't be able to receive it into the record. Looks like you have a comment, Attorney Ramirez.
I do, Your Honor. No need to prolong this, but if there were interest in substantiating it, so the Diggers Hotline panel indicated that Mr. Lalonde rejected the offer of the educational course. Now Mr. Lalonde is indicating that he does not recall ever being offered it or rejected it. And this sort of gets to the reliability and then why we obtained the record related to that, because we believe that denying an educational course with no forfeiture at the time shows a disregard. We're able to overcome and get a statement from Mr. Krieger to file after this. As you see in the records that we filed with the voicemail, there's an email going along that was received from the Diggers Hotline to WPL. And also, if Your Honor is willing to accept it, under the reliable hearsay standard applicable to administrative proceedings, we believe that that email shows the support for this, as well as the testimony of Mr. Mice, who was the one who obtained it on behalf of WPL.
Go ahead, Attorney Rogers.
I wonder if the court would entertain a closed session in which WPNL may be allowed to refresh the recollection of or to present the alleged voicemail to the respondent and offer opportunity to refresh his recollection. Since we have him here today, that might be a efficient way to verify this evidence.
No, I'm not going to be
Your Honor.
doing anything here because of the profanity ban. So,
Your Honor,
Yes.
I apologize.
Go ahead.
Oh, where I would leave it for the sake of it, to your point, it doesn't substantiate whether or not the violation occurred. We offered it for purposes of the blatant disregard for it. So where WPL would leave it would be, Your Honor, we believe that with the record we've presented and having witness Mice available here to speak to it, and the documentary trail for Chad Krieger from Diggers Hotline, that we would be able to meet the standard that applies to reliable hearsay for an administrative proceeding, and leave it with Your Honor to decide that standard as whether or not this comes in.
Well, refresh me on the standard you're talking about, because I don't see how we're verifying the conversation either way.
I have one moment, Your Honor, to
Yeah, go
refer
ahead.
to the private.
Let's go off the record. We're waiting.
Would you like to go? I'm prepared if you'd like
Yeah,
to go
okay,
back on
it's
the
back
record.
on. It's fine.
Okay. So from the recommended ALJ decision in 9300 PLI 112, there was a discussion about uncorroborated hearsay allowed with limitations for Wisconsin administrative agency proceedings. And it indicates that an agency may receive uncorroborated hearsay into the record, allows for the receipt of uncorroborated hearsay, just may not find based on unreliable facts. And so it may not rely on an uncorroborated report if there are internal inconsistencies between multiple reports, or allegations controverted by incredible in-person testimony. Under these circumstances, in order for an agency to make use of such report, the sponsoring party may corroborate and clarify the contents of the report with testimony. This provides sufficient due process. And we would say these standards are met because the voicemail is consistent with the Diggers Hotline panel. It's consistent with the chain of custody communications, where you see that the request from WPL for any records received by the hotline from forward contractors It contains no inconsistencies that have been identified. And we believe it has not been controverted by any credible in-person testimony. The individual just indicated he does not recall that, has not stated that in any way that it's a false indication of his communications and rejecting an educational course. With that, I would leave it with Your Honor.
Your Honor,
Yeah, go ahead.
Your Honor. This alleged voicemail, obviously I was returning a call. Where's the second half of where's the conversation prior to me leaving an email? I object to this being allowed because it's one-sided. And furthermore, the email is dated January 10th, 2023, and it simply states that I dispute the claim. It doesn't say anything about education. And furthermore, where is the offer of education from Wisconsin Power and Light to me? I'm still a little bit dumbfounded on this, I don't know how to say it. I'm not an attorney. I'm a contractor. But I object to this, and I would like the proof that they offered me this training.
Okay. Yeah, so I'm not going to entertain the entry of the voicemail into the record. I think the only way to verify that would be through Chad Kruger's testimony, and he's not available to do that today. In terms of verifying the Diggers Hotline panel summary, do we have any other evidence that corroborates that the respondent was offered the education course as has been described in the summary?
Your Honor, to clarify, WPL did not offer the training. It was the panel that offered it, and then this is the panel's referral to the commission. Not familiar with an instance where then the credibility of the panel's statement to the commission has been rejected as inadmissible or unreliable, to the point that if we're entertaining not accepting the statements made within there, we would ask for a recess to get in contact with Chad Krieger to allow him to substantiate, because this is on the statements of Mr. Lalonde alone, and in contrast to a fairly long record. Now that the agency's entertaining not allowing this information, we'd ask for a recess to get in contact with Chad Krieger.
I object, Your Honor. I object. This has gone for 2 years, and I've been in contact with PSC several times. A little bit because I'm technically challenged, but we don't waver nor do we run from this. We understand what happened there. We understand, but we don't want to recess and continue this. I think that we need to move forward without that evidence.
Your Honor, we could pick it up on cross-examination of Mr. Lalonde, where he will be under oath about whether or not he was offered the training and whether or not he rejected it.
Yes, I believe that's appropriate. In fact, I had planned to swear him in now, and I neglected to do that. But let's wait for cross. I think we can proceed. I think that the statement that may be challenged in the Diggers Hotline panel summary can be overcome on cross or additional direct if necessary. I would allow calling Chad Kruger back in a subsequent day if it's necessary so we can ascertain the facts from Diggers Hotline side of the situation. But let's see what the hearing today reveals. Yeah, and like I said, I do not believe still the facts we are talking about here is not necessarily determinative of the violations being alleged. So we're looking at the sort of extraneous standard of cooperation with the process rather than if violations occurred that are bound by the statute. So let's proceed. So my decision at this point is to reject the exhibit MEIS 1. Should we need to recall or need to call Chad Kruger, I can reevaluate that decision in another day, but the requirements of the exhibit would have to be met first, the ones that I described prior to this discussion. So let's proceed with
Your
the
Honor,
document. Yeah, go ahead.
just to expound on that, is there any transcript, because that is a voicemail, I'm returning someone's call, allegedly. Where is the first part of that? I think they need to, they want to bring this testimony from this person, but what triggered that alleged voicemail is what I'm still a little dumbfounded by that.
Right. So I understand that. So my answer is that should they wish to pursue this, and so I will not go to another day of hearing for that reason alone. But should I find that there's a need to have Chad Kruger be called to verify documents that you're contesting, the ones that we are going to enter into the record, then if that's going to happen, I'll allow Wisconsin Power and Light to submit the transcript of the voicemail in its proper form, and then have Chad Kruger as a witness verify it and discuss and provide foundation. So that person, he would have to discuss its origins and how it came about, and that it's the authentic situation. I think it would be wise. So assuming what's happened is he had left you a message and you're responding back to him. So the best thing would be to have that message be provided, or his recollection of that, of leaving that message probably be the best we could do. So we'll have to play that if it does occur, but that would be a question for a later date. You'd have an opportunity to question Chad Kruger as a witness at that point, if we do proceed along those lines.
Okay, thank you.
All right. So the next part of the process is to identify the documents we're accepting for the record and have them verified by witnesses. And we'll take the complainant first. So we have Wisconsin Power and Light Company. I believe they have 3 witnesses available, and they will be offering the documents that appear on the list that I've displayed on the screen share. For the record, and just so we know, this is from an email presented from commission staff that was the 24th of July. So these documents were all shown on the commission's electronic regulatory filing system, and we can have Wisconsin Power and Light call its witnesses and have those verified. And there'll be an opportunity for comments from the witnesses as well as cross-examination by the complainant and commission staff. So why don't we go ahead with the first witness from Wisconsin Power and Light.
WPL calls Dustin Gassner.
Okay, so just have him come up to your area there. Okay, witness Gassner, I'm going to swear you in, so raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
All right, so you'll have to pick up that mic. It's not coming out very well. There we go. Try it one more time.
Yes, I do.
Okay, great. Thanks. Go ahead.
Could you please state your name for the record?
My name is Dustin Gassner.
And did you cause to be filed in this case direct testimony and 1 exhibit?
Yes.
And if I asked you the same questions today, would your answers be the same?
Yes.
And is the information contained in your testimony and exhibit true and correct to the best of your knowledge?
Yes.
Your Honor, this witness is available for cross-examination.
All right. So we have questions from Forward Contracting. Mike Lalonde, any questions?
I do. In your testimony, you say approximately 12 inches below the surface. What surface are you talking about?
So I'm going to ask if we just go off the record for a sec. If you happen to have the page number of that testimony, would be useful just to direct the witness to. I think I may have found it here, which is page 4, Gassner 4, where he says it appeared that the line was approximately 12 inches below the surface at the location where it was damaged. Is that what you're speaking about, Mr. Lalonde?
I am.
Okay. All right. So let's get on the record. So it looks like, so we found the passage that Mr. Lalonde was referring to at Gassner, page 4. Do you see that statement, Witness Gassner?
Yes, I do.
Okay. And do you remember the question, or should we have it read back?
I remember. We took a location off of the top of the existing concrete.
Okay. And your testimony is approximately 1 foot. Is that typical for gas lines to be? And I verified this. You'll see that I called a hotline in last week. And I wanted to verify the depth of that line. And I also wanted to verify if they had moved it. But it seems like it's less than a foot. And is that typical of installation of, and this is a gas service, is that right?
Your Honor, just objection to the form of the question. If we could, there were a few things in there. Give Mr. Lalonde another opportunity to help Mr. Gassner understand the question.
Yes. Okay. So if you could ask one question at a time. I know you're kind of forming them as you go, but just try to get one question in at a time, and you can kind of build from one question to the next.
Okay. And the first question is it typical that you find gas services less than 1 foot below the surface of concrete?
No.
Do you install services less than 1 foot from the surface of any surface?
No.
Why would you think, excuse me, I don't know the term.
That's okay.
I'm going to say this question again.
Yeah.
Okay. Why was that service so shallow?
Objection calls for speculation.
Well, he's an expert and he's a witness, and he's has the knowledge of a professional that installs these. So I think I don't know how that would be a difficult question to answer.
Okay. Well, I can have him answer to the extent he knows, but I think in terms of the violations of the statute, the depth is not really an issue, just so you know. That's not really what the statute requires. But we can have him answer that question to the extent that he knows the answer.
When Alliant Energy or WPL or our contractor installs any services, we have a work practice stating that we have a certain depth requirement to meet on private and in road right of way. And we expect and maintain them to install as far ourselves to install at grade of what what our rules say, which is Alliant Energy rules on private property is 18 and federal is 12. And we expect our contractors to install at the Alliant Energy ruling, which is 18 inches on private property. And once it is installed, we have uh, we have no determination of what happens on homeowners' property after that. So we mandate that it's installed properly at the time of installation.
Okay. Any other questions?
Yep, I do. I have a couple more. All right. Where the alleged hit was, where the pin allegedly hit the line, was that in the right of way or out of the right of way?
I am not familiar exactly where the road right of way would stop. Most road right of ways end on the backside of sidewalk. I am not exactly sure. It could be a couple inches further on the backside of the sidewalk, so I have no information on that right now.
Well, was the damage to the line directly behind the concrete sidewalk form? Was it within a foot of the sidewalk?
Objection is to the form of the question. Just which question is the witness to answer?
Just restate that. It'll be okay.
Okay, was the damage within 1 foot of the back of the concrete form or sidewalk?
Yes.
And do you have any pictures showing the damage?
One moment, Your Honor.
I can go off the record. So, yeah, I know there's a number of pictures. Sure if this is helpful.
Your Honor, would you be able to put on the screen data request PSC Gagliardo 2 RG6 attachment C?
Yeah, I was attempting to do that, figuring that's where they were, but it wasn't actually showing up for me. Not sure why. Let me just go directly from Earth. Oh, I see. Okay, so it looks like it's a spreadsheet. And so it's an attachment. Okay, there we have attachment. Just the screen so we can see it better.
In the next tab, there
That's
we
it's
are,
the
Your
other
Honor.
tab. That was the problem. Okay, excellent.
And then
All right. So do you have a particular
you
picture?
could, yes, Your Honor, the one on the left, if you could zoom in.
Okay, so let's get on the record and just have you identify where we're at before I change the image here.
Have me do it or the witness, Your Honor?
Sure, the witness will be fine. Yeah, I want to do that.
So actually, after I said that, I should probably identify the document. So the document that the witness will refer to is response data request PSC Gagliardo 2, PSCW -RG-6, attachment C in the tab damage pictures. And then I would refer it to the witness.
All right, thank you. Okay, so we have the picture there. Witness, Mr. Lalonde, did you have a question about that?
Yeah, how do you know the pin damaged the line? I don't see any, I see no pictures of it actually in the line. I don't know if the pin even hit the line. And looking, this is the first time I'm seeing this picture, so you have to excuse me. But did you see the pin in the line?
As I started to excavate with a shovel to uncover the damage for Vanguard to take pictures and myself, that pin did not stick into the service line. It did fall out, but there was a hole in that 1/2-inch service line. And when after I arrived, the fire department did point me in the direction that they thought the gas smell was coming from. I did verify with my CGI. It's a combustible gas indicator. As I wiggled the pin, I could actually hear faint hissing coming from that pin, and I knew that that pin had either punctured or nicked the line.
So I just want to clarify, when you're saying the pin, do you mean the stake that was used to place the concrete form?
Yes, the concrete stake.
Sorry.
Okay, that's fine.
So the answer is no, you did not see the pin in the line. Is that correct?
Until I uncovered it, I did not see the pin actually in the line.
Could have something else punctured the line? And just answer that one, please.
Objection calls for speculation.
Okay, that's,
Well, he's a professional.
well, I don't think it really calls for professional decision. I'm going to sustain that objection. That wouldn't be impossible for him to answer that.
Okay. Is this, let me phrase this. Do you think this was done on purpose and with malice?
Objection calls for speculation outside of the witness's foundation to make an assessment of the mental state.
Yeah, I'll sustain that. And that's really not a standard in this proceeding. So there's no intent or malice required, just so you know.
He can't answer that if it was done on purpose or not on purpose?
No, I don't believe he could give us an accurate answer to that.
How many, this is to the witness, how many damages similar to this have you seen?
As of today, memory serves me right, 1.
And when lines are damaged, are they always damaged by form pins, or can other things damage the line?
I'm sorry, what was the word? Are they always damaged by?
A form pin, or can other
No, we're just not we're not hearing that word. Did you, just off the record for a sec, we're not hearing that word right. Did you say 4 pin?
Oh, yeah, it says form pin, and we'll just reference them as pin. Yeah,
Okay,
it's a form pin.
All right. So I think in some of the documents refer to it as a stake, which is where I got that word from, and you're referring to that as form pin. Okay, so just so we know, we're talking about the same thing. All right, so back on the record, do you want to have him restate that, Debbie, or did you get the question there?
I have it.
Okay, all right. So did we have a question in the end?
Yep. Do you see other damages caused differently, or are all these damages done with a form pin?
When it involves concrete forming like what we see in the picture, it's always going to be the concrete pin because you're driving it into the ground. The forms sit on top, pins go in the ground.
And is your testimony that the line should be 18 inches according to your standards?
According to Alliant Energy standards at the time of installation, it needs to be no more than 18 inches below let me rephrase that. It cannot be shallower than 18 inches. It can be deeper, but without prior approval from an engineer, it cannot be less than 18 inches according to Alliant Energy standards.
And was this line less than that standard?
Okay, that's already established, right?
Okay. My next question is, have you guys lowered, now that you have a known line that is less than your standard, and knowing that there will be construction and activity in that area again, have you or your company lowered this line to your standard?
The only excavation that I am aware of that took place was to properly excavate to fix the repairs on that line that was damaged. And if it is deeper, it was only because the if you see in the green space there where the line comes into, we wanted to make sure that it was at the normal depth of what it should be, out of the way, just in case locates were not called in again.
So is your testimony the line has now been lowered to the standards of Alliant Energies?
In the area of the excavation, the line is below for surely below the 12 inches federally.
I'm not exactly sure what that means. We have a line that's less than a foot below the surface. You have an excavation of about 2 foot radius. You're telling me in 2 foot radius, you lowered that line, 6 to 8 inches?
The picture that you see up right now is a hand dig operation after our emergency locates were cleared and my equipment showed up. We dug further into the green space and further back to have enough room to fix the repairs. At that point, I know that it's going to be deeper because we have to dig out deeper to make the repairs, to have enough room for our irons and everything else that we got to get in the hole to make the repairs. The rest of the line,
and I appreciate. Yep, I'm sorry.
The rest of the line, I have no idea what the depth is running at because I fix it and put it to where it is legally for it to our standards. At that point of at the point of the repair, we make sure that it's where it needs to be.
Okay, well, thank you. So it's your testimony that from the alleged, well, no, it's not alleged, it was damaged. It was alleged it was damaged by a pin, but where the damage was done to the pipe going towards the private home or the private property, you lowered it. So it's also your testimony from the damaged area going into the right of way, you did nothing.
Objection as to the form of the question, and also the question about who took what actions is vague. Ask Mr. Lalonde to rephrase his question.
All right, and we probably, unless you're seeking clarification, we don't need you to have him re-agree with what he said before. So if you have a new question, go ahead and ask that.
Well, Your Honor, okay, I will rephrase that question, but it's still going somewhere,
Okay.
believe it or not. So where the damage was occurred and the line goes into the right of way back towards the road, did you lower that line?
In the area of the excavation, yes.
No, I mean, I understand you lowered it at the damage. Did you excavate and lower the gas, was it lead or I'm not sure what, the gas line going into the right of way towards the road? Did you lower that where the sidewalk is going through the parkway and behind the curb and gutter? That was all lowered. Was that lowered? Yes or no?
No.
So it's your testimony that you didn't repair a known danger to contractors in the right of way that you're permitted. Is that correct?
Your Honor, at this point, I would object to relevance. Now we're talking about actions that are far outside of the scope of this complaint, which pertains to, whether or not locates were called in, when the damage was done to the line. We're now asking about things that happened later in different parts of the line.
Okay, I agree. Let's sustain that objection.
Your Honor,
Yeah.
Your Honor, prior to this, they're trying to paint me as a pin driving ogre, that I had disregard for safety, and they're trying to build their case that I don't care about the safety of my men when they're working or the general public, but they're painting me that, but they did not lower the line when they had the chance to mitigate that damage or danger. That's where I'm going. So I'd like to ask the question.
They did answer the question that there's no change to the depth with the line as it's traveling out to the street. That's already in the record. So I don't know what else you need to ask. Certainly not what you were asking just now.
Okay, who would bore the costs of putting that line back to legal standards?
Objection as to relevance, and also objection as to we haven't established this witness has foundation about rate recovery or other charges for relocation of lines.
Okay, I'll sustain that objection. I don't believe he can answer that.
All right, I'm gonna our hits something that Reliant Energies fixes on a regular basis?
Can you define regular?
On an occurrence of, do you regularly, once a month, once a week, do you see this and have to repair these, be it an excavator bucket or, a rock or anything like that? Is this a regular, is this part of your duty? Are you, or the company's duty to just repair these as they're broken and then leave it?
Objection as to the form of the question. If the question is what's the frequency with which repairs are made, WPL has no objection to it. Not trying to be overly technical here, but that was definitely a compound question.
Yeah, I think that's a fair question. Let's have him answer that question to the extent he knows through personal experience. If he knows sort of the statistics of the company, that's fine as well. But certainly any personal experience he can give us would be fine.
Personal experience, I can only talk about the two districts that I have worked in. As the district that Waupun is in, last few years and including this year, there has been a high rate of service hits and main hits. I can't honestly sit here and tell you that it happens once a week. It comes in waves. You get sporadic ones where you may have a hit on a gas line, maybe once a month, and then the next month you could have 4 or 5. But yes, this is the duty of a gas tech here at Alliant Energy, is emergency response and maintenance, and this is considered emergency response, and obviously maintaining that line when it is hit to restore it to the proper function.
So this is what you do regularly. This is what you do regularly?
This is what we do when there are accidents and hits, is we fix them. So again, I cannot tell you that it happens once a week or twice a week. I can tell you that it happens, and it comes in different batches of numbers. Again, maybe once a week, maybe once a month.
And I think I asked this question before. Is it common these hits are typically caused by a line that isn't buried to proper depth?
I believe this is asked and answered. I also believe that
I agree.
it calls for speculation.
Okay. Sustain.
Yeah, I withdraw it. No further questions.
All right. Great. Any questions from commission staff?
No questions, Your Honor.
So, I was curious, one question for the witness, and the Gassner Exhibit 1 does show a picture of looks like the location, the site of the damage. Just want to make sure that's exactly what we're seeing. Is that right?
That is correct.
Okay. And so the pin or the stake has been removed in that picture already. That's what we're seeing there, right?
Yes.
Okay. All right. Just was curious about that. And okay, I think that's all I need for that. Okay, so any redirect?
Yes, Your Honor.
Okay, go ahead.
Your Honor, could you refer back to that photo you were just showing?
Oh, yeah, sure. I just closed it. Hang on. So it's Exhibit Gassner 1. Go ahead.
Mr. Gassner, is it correct? These markings were made in response to your emergency locate, correct?
Correct.
Your Honor, no further redirect.
Okay, yeah, thanks for that. All right, thanks very much. You're excused. And we'll have the Wisconsin Power and Light call its next witness.
Your Honor, WPL calls Wanel Trepanier Freeze.
Right, raise your right hand. Sorry, sneeze here. All right, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Could you please state your name for the record?
Wanel Trepanier Freezy.
And in this case, did you cause to be filed direct testimony and yes, no exhibits?
Yes.
And if I asked you the same questions today, would your answers be the same?
Yes.
To the best of your knowledge, is the information in your testimony true and correct?
Yes.
Your Honor, this witness is available for cross-examination.
Okay, is any questions from forward?
Yes, just a few. And you have to bear with me, please. I know I'm not very astute at this. So in your testimony, and on page 2 of your testimony, you say I did not deny having hit the gas line. And I'm just wondering, refresh my memory. Did you call me? Did I call you? How did this conversation come about?
You spoke with another member of my staff and asked for me to call you, so I returned your phone call.
Okay. Well, I appreciate that. And in that, what was the context that you were, I'm trying to piece this back together from my memory also. You say that, at that time, I didn't know if we hit your gas line or the gas line at all. And you say that in your testimony, did not deny having struck the gas line. Why would you put that in your, did not deny striking the gas line?
Your Honor, I believe I'd object to the form of the question. It seemed compound. I couldn't quite follow it. If Mr. Lalonde would restate the question.
Yeah.
Why in your testimony did you state Mr. Lalonde did not deny having struck the gas line?
During our conversation, you didn't make any comments to affirm that you or your contract company did not hit the line.
And in that conversation, do we talk about the removal of rigid pavement?
I don't recall specifically that topic in that term.
And in that conversation, do you recall speaking with me about the depth of the hit or damaged gas line?
I believe we may have had just an audio issue on our part. That'd be the request to have the question read back.
Okay, yes, let's read the question back. The court reporter will do that.
Question, and in that consideration, I'm sorry, and in that conversation, do you recall speaking with me about the depth of the, hit or damaged gas line?
Possible. I don't remember specifically.
Excuse me. I saw your lips moving before I heard you. Can you start that again?
It may have been possible, but I don't recall specifically that part of a conversation.
Okay. In your testimony also, you indicate that I say this occurs every few years for my company. Do you know of any other damages that my company does that I don't know of? And did I say that? Is that exactly what I said?
Your Honor, it's another compound question.
Yep.
If we could take them one at a time.
Please.
Okay. I apologize. I'm new at this. So in your testimony,
You were good. Just repeat one question and then we'll get to the second one.
do you know of any other hits that my company or damage that my company has done to utilities?
Only based on the comments that you made to me.
And in the testimony, he said that he believes that this type of work is performing and exempt from requires that apply to excavations under Wisconsin law. He indicated these types of hits occur every few years for his company. And that he never pays these kinds of bills and that does not plan to start paying now. That's what you said, and I'm just wondering, to my recollection, we have no other damages. And I'm just wondering, where did this come from? Do you think this might have been taken out of context? Do you think I may have been talking about removing the rigid pavements when I say this? Because we have a very good record. We have a mod of
So hang on, we can let you make a statement about, I'm sorry. I can have you make a statement about your company when it's your turn, but if we're just asking about what was stated in the testimony, we could just ask the witness to verify upon what basis did the witness make those statements and see what the answer is at that point, and then we can move on.
Okay. Why did you make that statement?
It was based on conversation with you.
Do you recall exactly what he might have said to you do you recall what he might have said to you during that conversation regarding this topic?
I recall several comments that he made that I probably, because we talked about profanity, I'm not allowed to share.
Okay.
But I do recall specifically that he did make a comment to the effect that he is exempt from this type of requirement with calling in locates with the type of work that he does. He referenced something to the effect of Trans 220 and that the Diggers Hotline requirements and state laws don't apply to him, and that he has this happen every few years. It's something to the effect of that he's had this happen before with his company, and he hasn't paid them up to now and doesn't plan to pay for them or start paying for them. I do remember that he said that to me.
But you don't remember specifics of the conversation, meaning that it was about the line hit or the conversation with Trans 220.
Those are some of the specifics that I recall.
Okay, moving forward, because I understand it's difficult, and I think this was taken out of context, and that's fine. We'll move forward. You say that in some damages, generally if an excavator damages a line, that you bill the costs, except for extenuating circumstances. What would be extenuating circumstances?
If Diggers Hotline had a ticket and our locator mislocated the line and showed that it was in a different location, then that that billing would then go to the contractor that provided the locate.
And would a shallow, a non-standard depth gas line be one of those exceptions or extenuating circumstances?
I've never had a situation that I have waived a bill for depth of a service.
Okay, thank you. No other questions.
Okay. And so, any questions from commission staff?
No, Your Honor.
I just had a quick question for you. Just in terms of following up on your last answer, have you ever waived a bill where marks were correctly located?
I don't recall. Like I would have to go back and do a lot of research to know if I had or not. And
Nothing comes
like
to
I
mind.
said, no, and even with depths, I would have to go back, but I don't really recall anything of that nature
Okay, thanks.
being the reason.
All right. All right, any redirect?
No, Your Honor.
Okay. So we have one more witness for Wisconsin Power and Light.
Yes, WPL calls Bob Mice. And Your Honor, could we go off the record for a moment before Mr. Mice testifies? I have a
Sure, yeah, go ahead.
question.
Yes.
Okay, may I proceed off the record?
Yes, we're on.
Okay, so Your Honor, to resolve the issue, any question regarding the veracity of the Diggers Hotline referral, Mr. Mice has additional exhibits to offer, which include the record, the letter that Diggers Hotline sent to Forward Contractors, along with a certified mail receipt signed by Forward Contractors. We would like to offer those as additional Mice exhibits under Mr. Mice, within the chain of custody being that he requested them from Diggers Hotline and that they are documents that then speak for themselves. So the question would be whether Your Honor would allow us to do that and how we may then get to all parties these two additional exhibits.
All right. So first of all, to get to the parties, let's email them right now to the service list and to myself. We'll mark them. So there's two documents. Well, let's get them first and then we can deal with that, what to call them.
Yes, Your Honor. There are two documents along with, then there's an email, a small email chain with each document.
Okay.
So the first one would be a letter from Diggers Hotline dated January 11th, 2023 to Forward Contractors with an email chain. And then the second exhibit would be a certified mail receipt signed by Forward Contractors with a small email chain to it. We have not yet formatted them as PDFs. If we could have a recess, maybe just 5 minutes to then
Sure.
have them be
Okay.
PDFs for the service list.
Let's do that. We'll go into recess and just email those out to us first, and then we can take it from there.
Okay. Shall we come back? What time, Your Honor?
Let's give it, well, I think 5 minutes will work.
Okay. Yes. Yeah.
All right. We'll check back in at 12:20 and see how we're doing.
Okay. Thank you, Your Honor.
Okay.
Your Honor, are you able to hear us?
Yes.
Oh, it looks like our camera got moved. One moment. And then off the record,
Yes.
the email, if it hasn't been received yet, it's been sent. So if I don't see it in my email yet, but it has been sent.
Okay. Well,
We could,
yeah, you want to proceed and then we'll take that when it comes in? That's.
yes,
Yes.
So why don't we
That's
get
reasonable.
started with the Mies, let's can't remember if I sworn him in yet. Do you remember that?
No,
You
no, we haven't.
didn't.
All right.
Back
Let's
on the
start.
record?
Yeah, let's get back on. Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth.
I do.
All right, go ahead.
Could you please state your name for the record?
Robert Mice.
And in this case, did you cause to be filed direct testimony and an exhibit mice 2 consisting of locate call records?
Yes, I did.
And if I asked you the same questions in your testimony today, would your answers be the same?
Yes.
And is the information in that testimony and those exhibits true and correct to the best of your knowledge?
Yes.
And then, Your Honor, the remaining direct examination I have pertains to, oh, here they are.
It's off the record. I haven't gotten them yet. It may take
Okay.
a bit of time for them to get through. So your remaining questions are based on the new exhibits?
Yes, Your Honor, exhibits mice 3 and 4.
Okay, so we could. Anyone else receive those emails? No, all right. All right. So why don't we do this? Why don't we switch gears and have commission staff testify at this point and verify its documents, then we can move back to Mies. I think, oh, I did get them now. Okay, great. We're still gonna need a minute to review them as well.
Your Honor, I have them also.
You have them? Okay. All right. So why don't we,
I do.
let's take a minute and do that. Let's see what they consist of. Didn't sound like they were too complicated. So we can be off the record if I didn't say that already. So, okay, so number 4 was just the receipt. Okay, and it looks like there was an attachment to this. Close the summary of the panel's results. Is that the report, the summary that we already have in the record?
I would have the witness answer that, Your Honor. It's not.
Yeah, just off the record. I was just curious. We can,
Yeah, I believe that's the document you already have.
okay. Okay, so is everyone comfortable that they've had enough time to review?
Yes.
Okay, all right, so let's get on the record. So it appears that we are going to, the Wisconsin Power and Light is planning to offer 2 new exhibits that weren't served prior to the hearing, and I'll allow that based on its materiality. We'll mark those exhibit WPL Mice 3, which is the email to Bob Mies from, I guess it's, ultimately, yes. Okay, so it's an email chain, but substantially the chain is an email from Chad Kruger to Bob Mies that contains an attachment, which is Digger's Hotline letter to Mike Lalonde dated January 11th, 2023. And then exhibit WPL Mies 4 is the email chain again, which is substantially an email from Chad Kruger to Bob Mies, dated Friday, July 26th, which contains the certified return receipt documents for the letter discussed in Exhibit 3. So we've marked those, and we'll have the witness and the sponsor verify those under oath, and we can proceed from there.
Mr. Mies, did you cause to be filed in this case Exhibit Mice 3 and Exhibit Mice 4?
Yes.
And is the information in those exhibits true and correct to the best of your knowledge?
Yes.
And did you obtain these records from an individual you know to be employed with the Diggers Hotline?
Yes.
Your Honor, WPL has no more questions for Mr. Mice, and he's available for cross-examination.
Okay. Yeah, I just wanted to clarify. Let's get that on the record then. In WPL Mies 3, it references, it shows, and I'm going to show that on the screen share, but it shows the document, the letter sent to Mike Lalonde, and in the body of the letter, it does reference an enclosed summary of the panel's results. That's not included in this exhibit, but can you just tell me where that is included in the record?
Your Honor, it's in I believe it's in commission staff information.
Okay, okay, yeah. So So my understanding is that it's the Diggers Hotline Enforcement Panel referral. Is that, and just have the witness answer that?
Let's have the witness answer. Could you put it on the screen, Your Honor?
Sure.
Yes, that's it.
Okay. All right, thanks. Just want to be sure we have that, tied that down. And then one other question I have for the witness. It's true that you did offer an exhibit 1. Is that correct?
Yes.
Okay, and it's subject to my ruling earlier on. I just wanted to make sure that we have a true statement of that, well, all the documents that you offered for the record. All right, so we have questions for witness Meese. Am I pronouncing that Meese or
Mice.
Mice? Sorry, I knew I was going to get it wrong.
Yeah,
There's
Mike.
a 50-50 chance of doing that. Mice. Okay, thanks.
Okay.
Right, go ahead with
Mr.
questions.
Meese. Okay, Mr. Meese, did we have any phone conversations?
No.
And I'm seeing this letter. Did I reply ever in writing email that I wouldn't take the course offered?
I don't know that.
Do you have any letters, emails, or recollection of conversation of me not taking their hotline up on their offer for an education seminar?
Nothing other than the letter that you see there.
And was this letter sent certified? It says sent via certified mail and first class. I don't read. Yeah.
Oh, at the beginning? Okay.
Is it typical to offer this class or training when lines are hit?
This letter came from Diggers, so I can't answer that.
Okay. No further questions.
All right, thanks. And let me just add, I don't think I actually admitted those. I haven't actually admitted any of the testimony from the Power and Light at this point yet. So let me say that, oh, and let me back up. When it comes to the data request responses, are those being offered by witness Mice, or did we cover that? I don't recall hearing that. Maybe I just...
Your Honor, it's a good point to cover. My understanding was that commission staff was offering all data request responses under commission staff. So then to avoid duplication, when WPL witness Gassner referred to the photos, the only photo he sponsored in an exhibit was one that was not in a staff data request response. But in all other instances where he was referring to a photo that was, WPL's testimony cites to the data request response. The idea was going under staff.
Okay, so that's, I guess, I don't know if you have an opinion on that, Attorney Rogers.
No strong opinion. We haven't prepared, or we don't intend.
Yeah, that we don't need a special exhibit for this, but I'm just asking who's the best qualified to verify those? And if it's a response from the complainant, it may be better for the complainant to verify them. And I think, I believe the author of all of them was indicated that it was witness Mice. So I would think we'd want him to verify those two.
And Your Honor, that's consistent with our preparation of this table here. The other data request responses that Ms. Velardio will be sponsoring are from a third party.
Yes.
Upon in the fire department.
Okay, so let's have the witness now just verify the data request responses that are listed under Wisconsin Power and Light's name, and I just reviewed them. They were all filed or authored by the witness, so pretty appropriate for him to verify those as well.
May I address that just by
Sure.
by asking for all data requests? I guess
Well, you can just
I'll ask the
refer him to
question, but
the,
if, let me know if you have a preferred way of asking it, Your Honor.
you can refer him to the screen share.
Okay. Mr. Mice, please refer to the listing of data request responses, which generally include RG 2, 3, 4, 5, 6, 6 attachment C. Did you cause these to be filed in this case?
Yes,
And to the best of your knowledge, is the information in the exhibits true and correct?
yes,
Okay, great.
Your Honor, does that adequately address the issue?
That's perfect. And
Okay.
so I can accept all those documents listed under Wisconsin Power and Light, numbers 1 through 12 for the record, as well as mice 3 and 4. Okay, so that's our witnesses for Wisconsin Power and Light.
We did have redirect for Mr. Mice, Your Honor.
Okay, yes, okay, please.
Mr. Mice, you were asked if you have reviewed any record of forward contractors rejecting education. Do you recall that question?
yes,
Have you received a record from Diggers Hotline of forward contractors rejecting education?
yes. The copy of that letter that showed that he rejected it.
And just for clarity's sake, the copy of the letter from Diggers Hotline reporting to the commission that indicated that the offer had been declined. Let me refer to that. Your Honor, when you shut, okay, you already have it on the screen. Okay. Mr. Mice, this letter indicates respondent declined education and asked to be referred to the PSC. Does that correspond with all of the information you received about this case to date in your communications with Diggers Hotline?
Yes, it does.
Can we go off the record for a moment, Your Honor?
Yes.
And with that, then, rather than pursuing anything related to the voicemail, believe that that's our attempt to just corroborate that the respondent declined the education. May we leave it at that?
Yeah, that's
Okay.
fine.
I would object to that. I would object to that.
Well, you have a different view, I understand, and that's, I think in terms of what the complainant is presented, that's falls under their presentation is fair on their end. It doesn't mean we have a definitive answer, but it means that's their case, and I think that's fair for them to make that case.
Okay.
Yeah, so yeah, you may have a different opinion, and we can hear that now. In fact, do we have any other witnesses for Wisconsin Power and Light?
No, Your Honor, and no further redirect for Mr. Mice.
Do you want to say that on the record?
Oh,
Oh,
yes,
yeah.
please. So any further witnesses from Wisconsin Power and Light?
No, Your Honor.
All right. So now we have an opportunity for the respondent to present testimony. So what I'll do first is swear you in and get your name. I can just ask you there are a few questions I had just to form the basis of your presentation, but then you can have an opportunity to present your case and to rebut the statements you've heard either in the documentation that was presented in this email that I have on the screen, or the statements you heard today. So let's first swear you in. So raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. So give us your name, please, and your title.
My name is Mike Lalonde, and I am the owner and president of Forward Contractors.
Okay, great. And were you the owner and president during the time that the incident occurred?
Well, this is a different company. This company is no longer operating. But yes, I was the president. Well, I was a member. That was an LLC. So I was a member, the managing member of the LLC at the time of this damage.
Okay. And then I did have a couple of questions just for background. Were you present on the scene when the damage occurred?
No, we were not.
Oh, okay. When you say we, who are you talking about?
Me or my crews, and in my work. I think it happened on a Friday. I'm not exactly sure, but no, we were not on scene. We were already gone for the day.
Okay, so you were you working on site that day?
We were working on site that day. Yes.
So you and your crew?
Yes.
Okay. Okay, and okay, so go ahead with your presentation. Again, like I said, you can give us your side of the story, and you can dispute what you've heard today or the documents that have been filed in the case. Anything that you want to give in terms of your opinion, please do that. One thing I will offer is that in terms of applying the law to the facts, there will be an opportunity for you to file a brief in which you would tell us, well, this is how the facts line up with the requirements of the law. That might be, I mean, I understand you're not an attorney. That could be a complicated thing to kind of parse out while you're speaking here today, but just keep in mind that you will have an opportunity to give us your legal opinion on the case later. But do your best now, and I'll kind of direct you if you're kind of getting me confused. It's probably a good test. And then if I need something else clarified, I'll let you know.
Okay, I'll try and make this short and concise. So Forward Contractors is we were about 15 men. We do sidewalk repairs throughout the state, southeast Wisconsin, Beloit, Kenosha, many different municipalities. We typically will call in hotlines for all of our projects prior to starting. This project, which is in a different area where typically we don't work, the hotlines did not get called in, and this particular site was added to the contract, and so I'm a little dumbfounded on the whole thing because we typically do it. We don't dispute the fact that we did not call in hotlines. We do dispute the fact that we don't do it at all. I dispute the fact that they're saying that I'm reckless or abandoned, that I'm rogue. That's not true at all. That's painting a picture that is not consistent with the way our company operates. And yes, a mistake happened, and with the Wisconsin administrative law, we have responsibilities. I have a responsibility as a contractor to call in hotlines and work. I can't go and tear up their equipment. I have to be considerate of their utilities and mitigate any damages towards them. They then also have an obligation as a utility permitted utility in the right of way to have these utilities at certain depths and so that they aren't a danger to people just working out in the street. So that being said, I think that I got painted as an older. I think I was more upset that we had a gas line, and I call these contractor traps, and I work with We Energies. In fact, I worked with We Energies. John Tice down here was their safety person. And I had him at my company safety meetings, him and his partner, when they were damage preventers for We Energies. So I don't want this Wisconsin Public Utility to paint me as this person that doesn't care, I'm reckless abandon. That's furthest from the truth. What happened here is we had a superintendent, myself. We screwed up and didn't call on the hotlines. We admit that. I think that this got blown out of proportion as things were going. That I said, hey, listen, there's costs involved, and there's a reason why we have these lines at a certain depth, and that they're saying that in one testimony was I'm not under the regulation, or I'm exempt from this. No, that's not true. What I'm saying is in the Wisconsin administrative law, there's a provision here that says that rigid pavements can be removed without a hotline, and that's because of cost. You don't have to pothole for pavements and stuff like that just because of cost. And that really what I was trying to convey with these people and saying, hey, I understand we need to call on a hotline, but we both have responsibilities here. You have a responsibility to maintain and put these lines in at a depth that don't create hazardous situations. And so we both had, we both made a mistake, and it's two wrongs don't make a right. That being said, as a practice, we call in our hotlines before we do work. I want to make sure everyone knows that we're on record that, yep, I don't believe I'm exempt or above any law. We've done that. We do that. You can check the records. We just got done with a project up in Waupun, but there was a hotline for it. So, you can text me on that. So that being said, I wanted to just sort of get out there that, nope, we're not above it. But we do hold people accountable. And just like we should be held accountable, and being held accountable means that there's costs involved. We had costs. We had to delay that pour. We had to come back and pour that pour. Those are all costs against us, which should have never happened because that line shouldn't be within a foot of the surface. Now, I know two wrongs don't make a right, but there's a real concern of mine that we have mitigated. We have pins. We have 4-inch forms. The pins that we use, we only drive in 6 to 8 inches. That's it. If you look at the picture, you'll see that the pins are way more out of the ground than they are in the ground. We do that on purpose to mitigate any damages to utilities. Now, this one's different. We didn't have a hotline, and we hit it. And it's if it can happen, when it's Murphy's Law is what it is, But I was more upset that they weren't taking responsibility for their line being so shallow to the surface. And I think that I didn't convey it, or I conveyed it as if I was above it, that's where there was. That's not it. What I was saying is we have operations that we're supposed to do. You guys have to have the lines in at a certain depth. We have to call in hotlines and mitigate any damages. I believe we did that here. And I think that our record will show we have no other hits. I have no gas hits in the 8 years I've been running my company, and I don't know how to prove that. My mod can prove that. We're safe. We're at a 0.83. So I really wanted to get that out in the open. The second thing I wanted is that I call them contractor traps, and I started down that. When they do a tap on a gas main, they have to leave a little piece of pipe, a 2-inch pipe that comes up. And they used to put them on top of the mains. Well, we knocked one off many, many years ago and shut down an entire city because we hit it. And since then, We Energies, we worked with We Energies at that time. It was down in Racine. This is 20 years ago. And at that time, we worked with We Energies, and we got them to turn the the taps to the side of the gas main so that where I'm potholing, I don't have a surprise of a 6-inch riser coming off a main where I think I've got 6 inches and I don't. There's a piece there. So we're proactive. We understand the severity and really,
He got cut off.
Oh. All right, off the record. It could be his battery died. You might be able to hear me on Zoom. So we lost your phone connection, Mr. Lalonde. Hopefully you can hear us and call us back. So let's go off the record and wait a minute or so. Just push *6. We'll have you back on. You disconnected at the end there.
hello?
Yes, hi.
Hello?
We can hear you.
Okay.
Okay,
I'm
great. So
not sure when this phone cut out.
we'll read back. We'll
Um,
read back the last thing you said, and then you can continue from there if
Okay.
your stride. But let's pick up where you left off. So go ahead. Let's read back what he'd said.
There's a little bit of a long sentence. So, and since then, we worked with We Energies at the time. It was down in Racine. This is 20 years ago. And at that time, we worked with We Energies and we got them to turn the caps to the side of the gas main so that where I'm potholing, I don't have a surprise of a 6-inch riser coming off a main where I think I got 6 inches and I don't. There's a piece there. So we're proactive. We understand the severity and really
understand that the one call system is the way we've done it. This particular incident is an anomaly. It's not what we profess or practice. And that I think that some of my comments to them, because I was not very happy that there was a gas line within, less than a foot of the surface. And I think that's where a lot of this sort of animosity towards forward contractors has come from. But the long and short of it is we practice the one call. We use it on every project. Our record speaks for itself. This is the only hit we have in literally the existence of forward contractors. And, but we both have responsibilities. They have to make sure that that line is buried deep enough. We mitigate it. We put pins in the ground. Now, even though we call hotlines, we still only pound our pins in 1 foot because we don't want to be driving in, because this was a gas line, but if it's an electric line, it's a whole different story. So that being said, we're a good contractor. We believe in the system, and it's unfortunate this happened, but we're willing to continue doing what we're doing and mitigate any sort of damages to the utilities that we're working around.
Okay.
That's it.
So just curious, you mentioned that the name of your company had changed. So when you were saying Forward Contractors, that's the company in effect when the incident occurred?
Yeah, Forward Contractors LLC is when the company occurred. We are now incorporated.
Oh, all right. So it's just,
and that company is defunct.
So the LLC is defunct.
Yep.
And the current company is Forward Contractors INC Inc. Is that?
It's actually the name of the new corporation is Forward Contractors of Wisconsin.
Okay.
And then it's Inc.
Okay. Okay. So I was curious just to ask you, there's many documents filed here. Just in terms of the documentation that's we have on file here, is there anything particular you want to draw our attention to that you dispute about the the paperwork that we have on file? I think you've already mentioned the summary panel. You have a dispute with that. Is there anything else that you dispute is not factual?
Well, I dispute the testimony of, where is it?
I think we got that with your questioning. I think we understood the dispute you had with the testimony.
Testimony from Freeze. That's really it. And like I said, that I think this, I think there's responsibility on both parties.
Okay. Okay. Great. All right. Well, I appreciate your comment. So that'll be part of the record, and we'll use that to base the decision one way or another. We have cross-examination from the complainant. I'm assuming.
No, Your Honor.
No cross. Okay. Any questions from commission staff?
Yes, Your Honor.
All right, go ahead. Just introduce yourself. I don't think we may need to do that.
Mr. Lalonde, my name is Sophia Rogers. I've been working on this case as a staff attorney with Rachel Quagliardo, Alex Rodriguez, and Alex Pershling, who will be offering testimony from staff later on. I know that you've had calls with Rachel.
Yes.
One of the questions the judge has covered a couple of things for me. Just one moment. Actually, Judge, may I have a few minutes to pull together my examination?
Sure, we can go into recess. What do you need?
Just 2 or 3 minutes.
All right, well, let's go off the record. We'll just reconvene at 1 o'clock. How's that?
That'd be great. Thank you.
All right, that's great. Thanks. Okay. People are gonna hold me to that 1 p.m. So we still got a couple seconds. All right, so are we ready?
Yes, Your Honor, thank you for that extra time.
Sure, no problem. Let's go on the record and go ahead with your questions.
Mr. Lalonde, are you back with us?
Yes. Yep.
So, Mr. Lalonde, you stated that your company name had changed, correct?
It has.
So it used to be called Forward Contractors, LLC, and now it's Forward Contractors of Wisconsin, Inc. Is that right?
That is correct.
Okay. And did you say that was essentially the same company?
No.
Can you clarify the differences or the change that's been made?
Yeah, there's a couple. There's obviously it's incorporated. We're a C corp now, not an LLC. And then also we do other venues where you're doing inside concrete, a little bit more industrial concrete instead of the sidewalk variety. And then third thing, I think that's about it. Yeah, that's.
Okay. And I apologize.
Yeah,
I have,
the other, my last company was, I'm sorry, there was one right on the tip of my tongue. I just couldn't think of it. Forward, the last company had a signed contract with a union. So Forward Contractors of Wisconsin doesn't have that.
Thank you so much. I apologize to the court. I have cleaning folks coming to my apartment right now. I just have to let them know that we have to be quiet. Thanks.
You're good.
First world problems.
Yeah, that really is.
That's exactly right. I'm sorry.
It's all right. Go ahead.
You're fine.
So you do some different things, but some similarities as well. And I'm hearing that the company's expanded in scope. Are you familiar with the obligation under the one call law to notify the transmission owner upon damage?
Yes, and that's funny that you say that. We had no idea anything was my people did not have any idea that anything was damaged. In fact, I found out about it after the weekend when we came to the site and our forms were all tore up. And then I got a bill from the fire department for their response. So no, yes, we have an obligation to call Diggers Hotline or the utilities owner if we knowingly have hit it. We have no idea. No, and this is still a little gray area. I mean, typically when you hit something like a gas main, you'll hear the hissing and stuff like that. None of that was relayed. No one knew on our behalf that anything was not typical in our construction. So no, we did not know we hit any line. And I still don't know. I don't know if my pin hit it or a rock hit it or a root hit it or whatever. But to answer your question, yes, we know that it's our obligation to notify when we hit. But in this case, we did not know there was damage.
Okay, and I'm trying to make sense of that. You said you were one of the people on site, right?
Yep.
And how many other people were there?
Well, on site, we had a crew of 15 people working throughout the town. So there's only 2 form setters. I wasn't there when they put the pins in, but there was just 2 form setters, and they just go and put forms in the ground and they put the pins in and they go to the next hole and the next hole. But we had another crew come in to fine grade the site, to grade it, and they didn't smell anything or hear anything or anything either. So there's 2 crews that went by there that didn't know that there was an issue with the gas below them. And that's where I want to see if they have the section line. I really find it hard to believe that's like a miracle shot to do what they're saying happened there. Now, I'm saying that it's not impossible, but I haven't seen the pin in the line. I haven't seen any of those pictures. And I don't want to dodge anything, but there's a lot of things that could happen there. You know, that a stone could have moved, a root could have moved, anything. But there was nobody on site when the gas leak was detected. It was later that night, actually. I think it was like 5:30 or 6 o'clock that night that they smelt the gas. But I'm not 100% sure on that.
Okay, and you haven't brought anyone with you today who actually was there when the line was presumably hit, is that right?
That's correct. But they're under my direction.
Right. So you were not there when the glass was when the line was hit.
Well, when the pins were drove, I was not there when the pins were drove. I don't know when the line was hit. Everyone's assuming it was hit when we drove the pin, but no, I wasn't right there.
Okay, so you don't have firsthand knowledge of whether there was any hissing, right?
I have nope.
Okay, and you haven't brought any witnesses with you to testify whether there was hissing?
I spoke with my people, and they had no idea there was even anything there. They were just as dumbfounded as me.
Again, you're not an eyewitness to this event. You didn't bring anyone with you who could testify as to whether there was hissing. Is that right?
If I need to bring somebody, I'm sure I can. But no, I don't have a witness now to testify for that. But once again, we had another crew come by, and then the gas department or the fire department was notified well after we had left for the day.
Okay, and you also were not there to smell odor. You can't tell me whether there was any odor from firsthand experience, can you?
You're correct. And I do know the smell of gas, so you're correct.
Okay, and I already asked whether you were familiar with the statutory requirement that you call the owner, and you seem very familiar with the requirement that you call an owner if you think that there might be damage. Are you also familiar with the requirement to call 911?
Yes, I'm familiar with that requirement, but once again, we had no idea that there was damage.
And are all of your crew members familiar? Are you doing trainings, and is in your experience, I understand that they're not here today, but is this something that all of your crew members would be aware of, this statutory requirement to call the owner of the facility and also to call 911?
The foremen and supervisors would have that, and we do toolbox talks, and I know that one of our toolbox talks is Digger's Hotline and utility safety. Don't pound pins over red lines. Don't pound pin. So yes, our people they're trained in that. And once again, that's why we try and mitigate any damage by not putting pins 2 feet in the ground. We're only pouring 4 inches of concrete. We only need 6-8 inches of the pin being in the ground to hold it securely. So to answer your question, my people are trained on hits and protocols when it comes to hits.
And just for completeness, are they trained to call Digger's Hotline?
They're trained to call. Typically, what will happen is there'll be a frontline guy, a laborer, or someone of a frontline guy. If there's an issue, they contact their foreman. Their foreman then can handle it if it's in their realm. Now, obviously, if it's a blasting 3-inch gas main, they're going to call me right away. And then I'm going to say, okay, call 911. You know what I mean? So we have a protocol too.
I think
My foreman would pretty much automatically call 911 if there was an immediate danger or a presence of something catastrophic happening. But once again, we had no idea this was hit.
Mr. Lalonde, I'm looking, I think, for a slightly different answer here, or I'm asking a different question from the one that you may have heard. I'm asking about calling Digger's hotline to request locates in advance of excavation now. I'm no longer asking about 911. Can you expand on any training that's being offered, or I'm going to back up. Is your crew aware of the requirement to call diggers before excavation?
Yes.
And is that a protocol that's followed?
In this case, it was not followed. It was a mistake. The person that calls in the hotlines is myself. I have a log that I keep. I was going to try and put that on one of the foremen as a superintendent. Since this happened, I've taken that back over.
Can you
I
offer
don't know if
any-
that answers your question.
Well, I'm looking for some kind of assurance that this is something that you're really doing, and I'm not hearing a whole lot of assurance. Could you illuminate me as to whether this is something that you've been doing consistently? I understand your company's taken on a lot more types of work, and you haven't had many hits or potentially any other than this hit in the past. And I'm just trying to understand if this was luck, or if this is this is something that could happen again.
So you're asking for my procedures. So I mean, maybe I can help with this. So the procedure is we were a low bid bidder. So we bid the city of Waupun work. In their contract, it even states, again, it's redundant. They state that you're supposed to call Digger's hotline. It's a contract. It's in everyone's contract. That was on my responsibility. When this happened, I was trying to delegate that, and that's where the mistake came in. And how we have remedied that is it's just much easier for me to call in the Digger's hotlines and keep a log when I'm doing my office work on Tuesdays or Thursdays. So to answer your question or protocol, when this happened, we were trying to make a change for responsibilities. Obviously, it didn't go very well. So since this has happened, I have taken the responsibility for calling all Digger hotlines, right? The ticket numbers that are kept here in the office, and then they're also put on the breakdowns for the men. Now, sometimes we'll have 500 tickets because, Kenosha, we did 500 locations in one city. So we'll have 500 ticket numbers. It doesn't, I can't put that on the foreman. He's going to lose or whatever. So it's kept here. But yes, and the reassurance is the proof's in the pudding. Check my hotlines, and we keep a log here. Since this has happened, like I said, it's only happened once. But right now we're working on a Milwaukee project where we're working right next to live cables. And yep, we had a toolbox talk about it. We had a state agency protocol. Okay, if something happens, what do you do? And yes, we're proactive in that fashion. But to answer your question directly, we were making a change. The mistake happened. We weren't notified of the damage until after we got back there. And I wasn't even, we had no idea we hit this thing for at least 2 days. We got back in and we saw that the forms were all messed up and that there was a line there, but we weren't notified that from anyone. So we got back to work, fixed the forms, and then we got to take care of this. Okay, take care of it. We left it. We came back after they got done doing the repairs, and then we poured it back in. I know I'm kind of rambling here, but the protocol now, as it was before this happened, was I administrate the contracts, and with the contract administration comes the calling in of the hotlines. The hotline is then given to the foreman. If the foreman needs a remark, he's responsible for getting a remark. Did that answer your question?
I think it did. I think that answered my question. Thank you for the thorough response. Have you paid WP&L, Wisconsin Power and Light for the damage that they billed to you?
No, I have not. And the reason I haven't is they have expenses, we have expenses. And I explained this to them that, hey, we're all in this. You're a permitted utility. You're a company for profit. And these are not uncommon and I'm a company for profit in the same way. And this doesn't happen very often. I ate the fixing of the forms, the regrading of it, the coming back and pouring a short load. I paid for the fire department. I paid for the city. There was another bill there for the water department. I don't know why, but, and I said, no, I disagree with paying the bill because I'm out just like you're out, and we're both at fault. I mean, that's been my contention the entire time. I understand two wrongs don't make a right, but we do have to be reasonable here and understand that there wasn't a bad actor here. It was truly an unfortunate incident.
I'd like to turn to some of the exhibits that will be offered or have been offered by staff and will be verified shortly by Ms. Gualiardo here. We have several notices, certified mail return receipts, data requests that we'll be offering. And Ms. Gualiardo, you're not going to need to do this now. I'm going to just direct my questions to Mr. Lalonde, and then later we can come back to you. So, Mr. Lalonde, my question for you, first of all, is do you remember receiving the initial docket letter?
Do I remember you broke up there? Do I remember receiving what?
The initial docket letter. And
I can put that on the screen.
Judge, yeah, that would be very helpful. Thank you. Our terminology for that letter might not be very familiar. Okay, so on February 14th, I'm seeing this letter. And Mr. Lalonde, I know that you're connected by phone. Are you also, you're able to see the screen as well?
I am able to see that, and that's February 14th from 2023.
That's right. Do you recall receiving this letter?
To honestly tell you the truth, no, I don't recall this. In fact, I've been trying to find the file on this project, and I have very little here at my office in regards to this. Well, I can't read it. Is this?
Your Honor, I would be happy to let the witness.
I have this letter. Excuse me. I have the letter. It's right in front of me.
Okay. Okay. So you have the letter. There's a couple of data request exhibits that Rachel will offer in a moment here. And I'm curious as to your process. You haven't responded to any of the data requests or this letter with any submissions.
I emailed a response. I was not able to use the portholes, and I tried to, and she can attest to this. I've called many, many times. And I think that me being just a little bit, I'm a little bit challenged when it comes to this. I know email, but there's a porthole and all that. So I sent a statement via email, and I'm going to see if I don't know if I have a copy of that. I don't know if it was an email or if it was a letterhead.
Well, Mr. Lalonde, if you want to take time to pull that up, I'm not going to stop you, but my question is, what's prevented you from participating in this case up until today?
Well, that's, I found a letter, it was dated April 10th. Well, it's just got to work its way through. I can't change people's opinions of me. We have to sit and talk it out. You know, I tried to do that, and I dug a bigger hole for myself trying to explain it. And so I was just going to let it take its course. I mean, I'm not in control of this. You guys are in control of this. So I'm along for the ride.
Okay, you had made some comments earlier about, you know, this is the first time I've seen this or that. I hear you now that you did receive. I don't think you're going to object to any of these notices. You can still do that, but I think I understand your position a bit better now, and I don't need to keep asking questions about the lack of participation here. Just one thing that we really are still looking for a response on, and that's the tax ID. So the forward contractor's tax ID, we had requested that in the initial, I'm sorry, in the data request that was sent twice to you. We didn't get an answer back. Now I'm hearing that the company is defunct, and we're really now looking for the Forward Contractors of Wisconsin, Inc. tax ID. Is that something that you're willing to provide to us?
Why would you need my tax ID? And by the way, I don't recall that at all, that you guys are looking for a tax ID. This is the first I'm hearing that, and maybe, you know, I don't retain things, you know, but why would you need a tax ID number from us?
So there are a few reasons why we request that, but the primary one is so that we know that when we adjudicate, that when the commission adjudicates the case, that we know how to assess your company. So by not providing that tax ID, you may be indicating to us that you're not intending to pay a forfeiture duly assessed.
Well, I think I answered that. I don't believe there's a forfeiture. Once again, this goes back to my reasoning. Two wrongs don't make a right. I'm being held to a standard, and I understand a mistake was made, but there was a mistake made by the utility owner also. And no, I mean, why would I give anyone my tax ID number?
Okay, so Mr. Lalonde, if the commission reviewing the record and the law, applying the law to the facts of this case, after your various opportunities to participate and the participation by the complainant and commission staff here, if after all of that, the commission agrees with commission staff's position that there should be a forfeiture assessed against your company, are you telling me that you do not intend to pay that forfeiture?
If that's the case, there must be an appeal process if that were to happen. And then I wouldn't be doing this. Someone else would be doing this for me. So once again, I'm along for the ride. You guys are in control. But even if I did read that, I wouldn't give it to you, because that's like my social security number. I'm not going to give that out to anyone. I mean, except for like the IRS, you know, unemployment. But you're saying that, so let me get this understood. So you would get my tax ID number, and what would you do with the tax ID number?
So in the event that there is a forfeiture assessed against your company, the tax ID is our receipt. It's our ability to assess if you're not willing to make that payment on time. We have in the back pocket that tax ID number.
That doesn't sound,
identify your company.
Yeah, that does not sound like something I would ever prescribe to.
Understood.
Because we have appeals, and I understand that, you know, we're innocent until proven guilty and everything else, but I'm just being very honest with you here. I don't recall you guys ever asking for that, but I pay my bills. The fire department got paid. The city of Waupun got paid. The only people that didn't get paid, and I explained it to Alliance, is that, yeah, I have damages too. We both do. We're all big boys here. I made a mistake, and that mistake, yep, I own it. But they have an issue out there too. And I'm a little put off that it's not, that it's still at a shallow depth, because now they're willfully leaving that out there for someone else to possibly hit. So, I mean,
Judge, I'd like to
and I
get back
guess
to my
this is-
line of questioning.
Okay, yeah, you
Okay.
made those points. We have those on the record, so you're good to go on
okay,
that.
I
Yeah, why don't we
apologize.
finish up, wrap it up, across, please?
Yep. Mr. Lalonde, I have to say I'm disappointed by these answers because in this hearing today, I had heard you say that you understood your company was not exempt under the law, and that there was something that was done wrong, and I thought that was an admission of fault here, and I was happy to hear you take that responsibility. Now I'm hearing that your intention is not to do that. Are you familiar with the definition of excavation under Wisconsin law? And I'll avoid answering a compound question, but are you familiar with the definition of excavation?
I believe so.
Okay, and do you agree that your situation fits under that definition?
I disagree with that.
Okay, so let's turn to, actually, I'll read it out for you, and you can tell me whether this applies. The definition, Wisconsin statute, of excavation is any operation in which earth, rock, or other material in or on the ground is moved, removed, or otherwise displaced by means of any tools, equipment, or explosives, and includes grading, trenching, digging, ditching, drilling, augering, tunneling, scraping, cable or pipe plowing, and driving, and means any operation by which a structure or mass of material is wrecked, raised, rendered, moved, or removed. So after hearing that definition, Mr. Lalonde, do you agree that your staking, concrete staking process would fit into that statutory definition?
Do surveyors call for hotlines when they put stakes in the ground? Do campers
I'm asking the
call for a
questions, Mr.
hotline?
Lalonde. I
I disagree with that. I disagree with the
Can you-
definition and what's out there. And this is where I think somebody's, we've got to be reasonable here.
Judge,
All right. And I understand that. And we have a reason that we have these in place is that there are safeguards from both the contractor and the utility. The utility has responsibility to maintain a step on their utilities.
Okay, that part
And
we've heard.
I understand.
We get that.
Mr. Lalonde, I need to be able to ask you some questions here and get responses, and I haven't gotten a response from you.
Okay.
So
I disagree with that definition. I
I'm not
disagree with
asking
that
if you agree with
definition.
the definition. The definition is enacted in law in the state of Wisconsin by the legislature, and it's longstanding. I'm asking whether, according to this definition, the activities that took place in the incident that we're here to discuss today, did that meet the definition that you see on the screen before you?
I believe it doesn't.
Okay. I'm gonna leave it there, I think. With this particular definition, and just going back to your statements earlier today that you understood you were not exempt, that you should have called Digger's hotline. Can you confirm? Wait, I'm wondering which it is. Was it a mistake? Did you make a mistake here and you should have called Diggers?
I've already said that. Yes, that's our protocol. This is an anomaly that, obviously we'll regret that it happened, and it is not part of our protocol. We call Diggers in, and you guys can verify that. I mean, you have Diggers hotline right here.
Okay, Mr. Lalonde, this was an anomaly. Do you recognize that this anomaly violated the one call law. The requirement, not just under your protocol, but under Wisconsin law, that anytime you're doing any of these things, you've got to call Digger's hotline.
I understand that now.
Okay, and now hearing that this is a violation of the law, if you were lawfully assessed a penalty, would you pay it?
I don't think I would answer that right now. I don't know what is the penalty. Once again, and what is the penalty for Alliance to have their line 1 foot below the surface? So to answer your question, I would consider it, yes. But if it's not reasonable, then I would appeal it.
Okay, and is there, so we're past the point of a settlement in this case. We've gone to hearing here. But if you, I want to let you know that there is, if the judge can please scroll down to, I think it's sub 3, there is a process that we use to settle these cases. And you would be within your rights to let us know if you're interested in a consent agreement. Now, we've way past our standard procedures for offering you a consent agreement, meaning a settlement. But if that's something that you are interested in, please let us know.
I am interested in anything to put this behind us and move forward and understand and learn from our mistakes. So to answer, I'm interested in any resolution that's reasonable so that we can move forward and put this behind us and learn from our mistakes.
All right, I'll say, I think it would be helpful to hear from you outside of this hearing process. Judge, would it be possible for to request a breakout room with me and Mr. Lalonde? So that we can.
Well, no, I don't think it's really appropriate at this time to break out and discuss settlement.
I'm not looking to this. I'm sorry.
Well, I think, I mean, we are in the middle of a hearing. We do have a complainant and respondent in attendance. I, be honest with you, don't know how the consent process interrelates with the hearing process. Now that we've noticed a contested case, settlements are available in contested cases, but to the extent that there's a separate authority to do that under Wisconsin statute 220, chapter 227, how it relates to the consent agreement process in chapter 182, I've never needed to understand or evaluate. So I think the best process at this point is to proceed with hearing, and I will be proceeding with my process as I discussed it at the beginning, where I'm going to be forging ahead with a proposed final decision, and there'll be opportunities to comment, to brief, and to comment. I can, if all parties and staff request that I suspend activity on that for some certain time when settlements will be discussed, I guess I can refrain from going ahead with my end of the deal here, but I don't know if there's I mean, I don't really hear that there's a likelihood of this coming to an agreement, but so far, but I don't, I mean, I guess what I'd say is if parties and staff want to take this offline after the hearing and meet and confer in terms of a settlement, I'll welcome that, but I don't think I'm going to facilitate that now. I think we need to proceed with the hearing and get that under our belt and then move on from there. So, so let's collect the evidence here. And then based on that evidence, I can proceed with the proposed final decision, or parties and staff can proceed with the settlement. And then we'll see where that goes. But at this point, we're collecting the evidence. So do you have any other questions for the witness?
No further questions, and I appreciate the consideration of that request. I'm recognizing that there hasn't been not due to any fault on staff's part, but there hasn't been a conversation about our process, and I want to make sure that we're able to handle any questions that Mr. Lalonde has openly, and so
yeah, I guess to be honest with you, I'm not exactly sure why, but that's okay. I did have a question though, and perhaps Attorney Rogers, you can direct me. I didn't see in the initial docket letter that there was an indication that a settlement process was available. Where did we communicate that in the letters that were sent to the respondent?
I didn't mean to indicate that we had put that in one of the letters.
But I just thought by matter of course it was in the letter, but maybe I'm mistaken about that.
I'm not sure that it is. We cite the statute generally.
Okay, so that's not our typical process, is not to inform respondents of the possibility of settlement. I thought we were doing that. But...
We do that at the point of admitting fault, which may have taken place just now in testimony.
Oh, I see. Okay. So that would be if the respondent responds with an admission, then staff will follow up with the potential for settlement. They'll offer the possibility of settlement at that point.
It is a case-by-case determination.
Mm-hmm. Yeah,
but there are benefits to the consent agreement process. And, in cases where it might be effective and beneficial to both parties to pursue a consent agreement, we do offer that. And we're favorable to that approach.
Mm-hmm.
We haven't had this conversation with Mr. Lalonde yet. And, I hear you that it's not necessarily the time to do that right now.
Mm-hmm.
So,
Yeah.
understanding that and sort of regretting even making the suggestion, I agree with the approach that you're taking. Let's just get the evidence in and move on.
No worries. I did have a follow-up question for you, witness Lamond. You did mention that you do toolbox talks. I just wondered if you could define that for us. What do you mean by that?
So we have subjects like next week we're going to have one on heat and being hydrated. We try and keep it relevant, and what it is the crews will end up coming into work, 10 minutes early. Usually that doesn't happen. Usually it's right when we're supposed to be working. They get the crew together, and then they discuss, kind of like the Milwaukee, working right next to live street wires. Next week we'll have one on temperatures and knowing the signs of heat exhaustion, how to prevent it. They're just topics, and I like to be proactive in that. And like I said, and I'm going to knock on wood, we have no, I don't want to say this, I'm going to knock on wood. We have no lost time. And just like I said before, we're very proactive when it comes to our work out in the field, because I have seen horrible things.
So when you say toolbox talk, though, is that something you do like on site where everyone's gathering around, or is this something you do in the office with your crew?
Nope, it's on site with the foreman. Typically, the foreman will do it. I'll give them a handout. They'll talk about the handout. Some of the foremen will get the guys to sign it. I just really, all I want on the toolbox talk is what we talked about, who was present, and then we just put it into our safety file. Some foremen do them a little bit more often than not. We try and do them once a month. I know that doesn't sound very frequent, but then when we get special instances, let's say we're working on an on-ramp, we'll do some stuff with some traffic control and how to assemble and disassemble traffic control. Just things like that. And yes, it is done in the field with the foreman or with the crew by the foreman.
Okay, and when's the last time you did one with respect to Digger's hotline requirements?
I think the last one we had was right after this happened. And I held it with the foreman, and I told them that there was a mistake made and that I own it, So I think that's the last time we had something with Digger's hotline. Specifically Digger's hotlines, because that really they don't really get into the administrative law and all that stuff. Like I said, I've taken that back over and I've supervised that now, or are responsible for that.
Okay, but does your crew know not to dig if a location is not marked?
Yes. Well, if there's no marks, they should be questioned. When we're in urban areas, there's marks all over the place. So yeah, they understand that. But yes, to answer your question, if it's not a hotline, they're notifying their foreman and me right away. Sometimes it's just that in working with, and I found this to be very helpful, is working with the guys that are out there marking it, getting to know them, the Milwaukee guy here, letting them know our procedure, where we're going, what we're doing, because I called it a Digger's hotline from Michigan Street, from 27th Street all the way to 39th Street. Well, we're only doing walk corners. And I don't want that, I tell them, hey, I'm just doing walk corners. You know what I mean? So I think it's a better communication. I think we have great communication, to tell you the truth. Like I said, they have a job to do, we have a job to do. And if we can help facilitate their job, they're just gonna help us to facilitate ours. So to answer your question directly, the last one directly discussing hotline would have been the fall of 2023. Or yeah. Is that right?
Can I just ask what those sidewalks were?
I'm sorry.
Oh yeah, wait, what?
What the sidewalks were, or the corners?
You said it.
Sidewalk corners.
What corners?
Yeah, sidewalk corners.
Oh, sidewalk corners. Okay, that's good.
Yeah.
Thank you, sir.
Okay, and then I just lost my question here. So I was just curious about the let's see, we're calling them stakes before you were calling them, what was that, pins?
Pins, yeah, we call them pins.
So wait, hang on, let me ask you the question. So how do you drive those pins? What do you use to drive pins?
Typically a 2 to a 6 pound hammer. It's just a sledgehammer.
Okay, and are they a standard size? All the pins are the same size?
Well, we have different size pins. We have 24-inch pins and 30-inch pins. Now you can get them in all different sizes, but we have just the 24 and the 30-inch. Now the 30-inch pins are for curb and gutter, where we have like 14, 15 inches out of the ground, and we're having to hold the form rigid. So that's something that you need a longer pin when you have a deeper concrete, is what it is. That's where we use the 24-inch pins. We typically use for our sidewalk. We do have 18-inch pins also, but like I said earlier, the 24 and 30 is our typical pin size.
Okay. Do you know which pins were in the ground at the site?
24-inch.
Okay. And you were saying you had sunk those, or the crew that you had sunk those in how many inches?
Typically they'll go about 8 to 12 inches into the ground. Because remember, we got to pull them back out. So the farther we drive them, the harder it is for us to get them out. So it's a win-win for everybody.
Mm-hmm. And the crew would usually like hold the pin with one hand and hammer it with the other?
Yep, they would hold it. Yeah, they'll hold it, and then if it's really tough ground, once you get it started, just like a nail, you'd let go and then hit with both hands.
Is there like a point on the end that you hammer into?
Yep, there's a point. So it's just like a big nail, except it's the best way. It's just like a big nail. It's got a point on one end and a flat part on the other end, so that when you're hitting it with the hammer, you get strikes.
Okay. But you would hit it point end down.
Yep. Yeah, you hit it down. If sometimes, yeah, you just hit them. You try and keep them as straight as possible.
Mm-hmm. Okay. All right, great. I think that answered what I was looking for. So where are we at now? Any other questions for the witness? It was a long discussion here. So if there are any questions, I'll allow that.
Your Honor, I do have some recross.
Okay. Yeah, let's go ahead.
Okay. Mr. Lalonde, can you hear me okay?
I can.
Okay. This is Zach Ramirez, attorney for Wisconsin Power and Light Company. Is it correct that the work at 540 East Franklin Street in Waupun was part of a broader sidewalk replacement contract?
That's correct.
And was the replacement at 540 East Franklin Street the only address where Forward did replacement work in Waupun?
No, that is not.
Was it the only address where Forward did work during the month of August of 2022?
No.
Okay, Your Honor, I have no further questions.
All right. Okay. So, yeah, go ahead.
We did the sidewalk program in Waupun last year, and you guys can verify that every location was called in Digger's Hotline. And there was probably 100 locations on that one.
Your Honor, just for making sure that the witness understood my question, so not objecting to his statement about last year. Mr. Lund, I was asking about during the month of August of the year 2022. So was the work at 540 East Franklin Street the only site that Forward Contractors did work in Waupun in August of 2022?
No.
Okay, no further questions, Your Honor.
Yep, that's great. All right, so I can excuse this witness then, and we have one more witness to take. I think we're going to need a break. So let's take a 20. Oh, well, we have a hand up there.
We're gonna be offering two witnesses. I hope I put it in my pre-hearing email, but
Oh, no, I don't. Oh, maybe I just didn't pay attention. No, I just see Rachel. That's okay. So let's take a break. I'm gonna give us a little more time than usual, I think. So let's get back at 2:30 and we'll continue from then.
thank you, Your Honor.
Thanks a lot. You can
Thank you.
mute and turn off your cameras. I would probably stay connected just in case we have trouble. All right, it's 2:30, so let's get back to it. We don't have Mr. Lalonde online yet. His Zoom presence is here, but not his phone. Let me okay.
There he is.
Okay, so we're ready to go. Do we have everyone connected? Looks
I'm
like
connected.
you're back on. Excellent. Okay, yeah, looks like we have company and commission staff. So I think it's commission staff's turn to call witnesses. So let's do that.
Thank you, Your Honor. Commission staff calls Rachel Gualiardo to the stand.
All right, see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, go ahead.
Please state and spell your name for the record.
My name is Rachel Gualiardo. Spelling for that is Guagliardo.
What is your position at the Public Service Commission of Wisconsin?
I'm a program and policy analyst with the Public Service Commission for the Division of Energy Regulation and Analysis.
And how are you involved in this particular docket?
I served as case coordinator.
Did you cause to be filed the documents in this docket, including the various notices to the respondent and the complainant, the data request to the respondent, and the exhibit appearing on the screen before us?
Correct. Those under the commission staff listed there.
Additionally, can you verify the data request responses that came in from third parties, the city of Waupun and the fire department there?
Yes.
Those are shown under 9, 10, 11, and 12.
Yes.
Okay, no further questions, Your Honor. Open for cross.
Okay, I just had a question, and maybe I just had to clarify we'll see who can answer this, but I was just curious. It looked like we had a attachment C that was filed as a response to your data request. And I just was curious, I'm looking at the data request response to RG6, and it does reference photos A and B, and they are attached directly to the response. Okay, so I got my answer for that. Sorry about that. I wanted to make sure we had everything. All right. So do we have any questions from the complainant?
No, Your Honor.
How about the respondent, Mr. Lalonde? Any questions?
No, Rachel was a great help. That's it. Just a statement.
All right. Okay, that's good. So thanks very much. You're excused.
Thank you.
Your Honor, may I call a second witness for the
Yeah.
commission?
Yes, go ahead.
The commission staff calls Alex Rodriguez. Stands.
See you there. All right, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Please state and spell your name for the record.
Sure. My name is Alex Rodriguez. Rodriguez spelled Rodriguez.
What is your position at the Public Service Commission of Wisconsin?
I work as a pipeline safety engineer.
And how are you involved in this docket?
I'm the assigned lead engineer for the commission, from the commission for this docket.
Mr. Rodriguez, did you hear the discussion earlier today regarding depth
Yes.
Do you wish to offer any comment? Specifically, how is the depth, the number of inches, is the number of inches, of depth relevant to your analysis in this case?
I would say no. It's, I wouldn't think it, well, the depth shouldn't really matter.
Can you clarify as to the federal and state requirements as to depth, versus the requirements of the excavator? And I'm looking for, just some discussion to.
Sure. Yeah. So I guess as far as the federal regulations that that my group goes out to enforce, that falls upon operators such as Wisconsin Power and Light. They're required to install their gas mains and their service lines at specified inches.
I'm sorry, at 5 inches, did you say?
No, at a specified depth, at specified inches. So
Can you keep your voice up a little bit?
sure.
Thank you.
So the operators, they're all required to install their mains at certain depths, and that's something that we'll verify when we're out in the field. But they're not required to maintain those depths. Any sort of things over time could affect that. Other work that's done by other contractors, homeowners could lower the depth of the soil above the pipelines. So do you think it'd be possible to give me 1 minute to see if I could adjust my audio settings? It might be picking it up through some sort of microphone that isn't great.
Yeah, let's do that. Go off the record. I
Sure,
would appreciate it. Yeah, thanks.
We forgot to test Alex's mic.
Is this any better?
Yeah, I think so. We'll try it. If you just speak up a little, I think just the volume of your voice may help too.
Sure.
Yeah,
is this
that's
any
much
better?
better. Yeah.
Well, the frog is gone.
The
Yeah.
fog. Okay.
I think.
All right, let's get back on.
Sure. Did you want me to repeat anything then from that? I could start over wherever.
I'm
No,
okay.
We got it all? Okay. Yeah, we're good. Thanks.
Okay, but yeah, I think the last thing I was saying was yeah, they're only required operators of gas pipelines. They're only required to install them at certain depths. They can't really account for unforeseen circumstances. Even naturally, the depth of the ground might lower as things compact over time. So.
What?
Anything else?
We're getting a little bit of audio from Mr. Lalonde. I don't know if he wants to mute.
Oh no, I'm good. I just grabbed a piece of paper.
Mr. Rodriguez, in your view, does the depth in any way impact the excavator's responsibility to call a digger's hotline?
No, I mean it's there. It doesn't offer a depth in the statute for where they always have to call if they're removing earth, if they're excavating.
All right. We've had some discussion of what might occur on the site of an incident. Did you hear some discussion by Wisconsin Power and Light's witness and the respondent as to odor and hissing that may occur upon damage to a pipeline?
Yes.
So let's just be clear that we're talking about a gas service line.
I'm sorry. Yes. Apologies. That was a misspeak by me. From your experience and your review of the facts in this specific case, can you offer an expert opinion as to whether the punctured service line would have been noticeable to the respondent, whoever was on site at that time?
Objection.
Yeah, okay. go
That
ahead.
is objection. He can't answer that. He doesn't know.
Well, I think he can answer to his expertise as to what someone would perceive if a line was punctured. Now you're assuming that we have in evidence, the question assumes in evidence that the line was punctured while the respondent was present. So I think we're really dealing with a hypothetical. So
Okay.
if
Well,
you,
Your Honor, we don't know if that pin punctured the
I
line.
understand, I understand. So what I'm giving the staff attorney the opportunity is to ask in a hypothetical situation, not in this situation, because I don't think the facts are established that the line was punctured in front of the respondent necessarily. So with that still in doubt, the witness can answer the question in his expertise as to should a line get punctured by a pin, such as the one that was involved in this case, would someone observing that be able to sense the puncture? So then we're not assuming that it actually did happen. We're just posing a hypothetical, and that's a fair question. I can let him answer that.
Okay.
Yeah,
Judge,
so go ahead. Do you want to, well, let me just ask the witness. Do you understand the question? I think.
I believe so.
Yeah, okay. Why don't you-
Yeah.
go ahead.
So, I mean, in a case like I guess is being described, I would think it would be noticeable. There's multiple things to notice. There's visual, audible, aromatic changes that would occur in the immediate vicinity when any natural gas line is struck. And the magnitude of these changes, they'd be more prominent if the puncture size increases, or if the line's at a higher pressure, or if it's even how close it is to the surface as well too plays into that. And I guess the line in question, it was operating at 55 psi, 12 inches below the ground, and for comparative purposes, you could think to air pressure being released from a car tire, which usually operates at about half the pressure, so if you're releasing gas from the air of your tire through the valve stem, you can usually hear that gas escaping. It makes a noise, and that's still readily audible. So in a scenario like the one being described, there'd be 12 inches of ground cover around there, but again, usually the sound would still be audible at a pressure like that. So, and another thing too is job sites vary. If it's you can have different sounds around. So if you're puncturing it with a backhoe or something, heavy equipment, oftentimes there's a lot of noise being made by that equipment that can make it difficult to hear. That'll dampen the sound. But if you're striking it with a hand tool, presumably right overhead of it, I would imagine that would make it easier to hear rather than more difficult in some cases that I've seen. So, and I guess too, apart from the noise, there's also the escaping gas will tend to kick up dirt too, depending on the condition of the soil. But you can actually sometimes see visually the soil being pushed around by the escaping gas. So I guess that's where the visual comes in, and then the audible, or the aromatic sense, I guess, would be all these lines. They have odorant injected into them by the operators of these gas lines, so that if someone does puncture it or there's any sort of accidental release, that individuals will smell it. And smell varies from person to person. And if it's deeper underground, there's going to be more layers of soil that could potentially act as a filter to that odorant as the gas escapes through the ground. But again, this was relatively shallow, and in a case like this, it would have been relatively shallow. So I would think, with all those three potential options, I would think it'd be likely that something would have been noticed to have been off in the environment. That would have been a sign.
Okay. And next question, go ahead.
Any other comments to offer, Mr. Rodriguez?
I don't think so. Nothing that hasn't already been
Okay.
established upon.
So I think we just need to establish your credentials. I think, especially with Mr. Lalande's question, referring to your expertise, I think it's appropriate just to get a little bit more about your background. Just tell us, your educational background as it relates to your position here with pipeline safety.
Sure.
Yeah.
Sure. So I had a 4-year engineering degree prior to starting this job, a mechanical engineering degree. So nothing, it was general engineering. And then over the past 5.5 years, starting January 2019, I've been working in the same position at the PSC. What, in short, what we do is we perform audits. It varies, but maybe 2/5, maybe half of our time we spend actually out in the field with gas operators such as Wisconsin Power and Light or any other ones around the state. And we'll perform field audits and we'll visit them. We'll watch while they do construction. We'll watch while they do any sort of the myriad of recovery tasks that they're required to do within federal and state regulations.
I'm sorry, was that recovery tasks you said?
Any of the covered tasks.
Covered, okay.
Yeah, so any task that the government says through regulations, you have to do this or you have to do this to this standard. So we'll be out on construction sites often watching them install pipe and watching them meet those depth requirements that they're required to by regulation. We'll stop out if we can, if there's an incident, and we'll see how they respond to that. So the past 5.5 years has just been that.
Okay. Do you typically do, or I guess to what frequency do you observe the placement of gas service lines like the one in this case?
Sure. I'd say that's fairly frequent. So roughly about maybe 40% of the days that we spent out in the field, not in the office, which I said, again, that was maybe half, 2/5 of our time. So again, maybe 40% of that time we'll spend out while they're doing construction of any sort. And that ranges. So maybe a conservative, a third of that time might be spent, maybe less, watching them install services such as this one. But
and have you, go ahead, sorry.
Sure, but the process for installing any sort of pipeline, there's similarities, there's differences. So the main in the street might be a very similar process to the service line in the customer's backyard, but it also might be fairly different depending on the location. So
Have you observed Wisconsin Power and Light installing gas service laterals?
I have, yes.
To what extent have they complied with the the depth requirements?
They have. I've never seen them fall out of compliance with that. If that's something that I did observe, I'd have to document that, and we in effect have to serve them a notice that we've observed them not complying with federal regulations. So when I'm out there, whether sometimes you can't even see visually them installing it, but you can look at their tools and it might say they're drilling in a line and it could give them a depth that it's 30 inches below. And maybe sometimes they will install it and they'll be trying to install it and it'll be at 10 inches below, in which case they'll have to just pull the drill back out and restart it again. So
okay, so there's some sort of obstruction that they can't go further than 10 inches.
Right, if they hit a big boulder or something and then put the drill head down versus keeping level.
Okay, so it's the tool that is used basically to judge the depth, how far the tool is in the ground.
It varies. That's probably the most common thing you'll see these days is these under these drills that sit on above the ground and then place rods further and further into the ground. You can also see them just dig up a hole and direct bury it is what they call it, where you'll just drop the pipe into the ground, make connections down there, and then place soil physically over the top. In which case, you can just see how far deep they are with rulers and whatnot.
I'm sorry, with rulers and whatnot?
Yes.
Thank you.
Tape measures, whatever equipment they have.
Okay, great. That's what I was going to ask next. Okay. And the required depth then for gas laterals, like the one in this case, is how many inches?
In the backyard, I'd have to, I'd say about 12 inches. If you look at the federal standard, though, I could pull it up really quick too. Just I don't want to misspeak, but yeah. So I was saying 12 inches, and that's what it is. So.
And just give us the citation for that if you have it in front of you.
Sure. So that would be that'd be the Code of Federal Regulations 192.361A.
Okay. And then, so that's for 12 inches, and that would apply in a front yard too. It looks like this is the front yard, the street side of the house.
That'd be in private, so that'd be in private property. So if it's in a street, then it would be 18 inches. So it varies on where it is.
Okay.
I believe Alliant Energy, they have their own internal standard where they say this has to be installed at 18 inches, no matter where, unless we get some sort of special approval from engineering, in which case they'd still have to comply with the regulations, no matter what, as a minimum, so to speak.
Okay, but the regulations would say 12 inches is okay up to where you hit the street line or the right of way? Any idea?
To clarify, Alliant Energy's procedures or the federal
what the actual legal requirements would be, the rules, federal rules that you cited.
Sure. So the federal rules would say that has to be 12 inches of cover in private property. So, and then if they're in the street or the road right away, it'd have to be 18 inches at that
Okay.
point.
Okay. While I have you, we had a couple of pictures being shown on the screen. At least we had this one, and this one is, I'm getting this right, attachment C to the response to the staff data request RG6. And to the best of my knowledge, I think what we established prior was this is the front of the site, the incident site, and it's showing after the emergency response took place. And I just was curious, do you have any comment on this picture? Anything you'd like to highlight or bring to my attention?
Just generally, you're wondering, I guess.
Yeah, just anything that comes out at you that you think I should know while trying to decide what happened here.
Sure. I mean, so this is obviously post damage after it was called in. So I think they were stressing that too, where the paint markings, you can see what's located there is the gas line, but that was a post incident locate, so that wasn't there prior. And you can kind of see that too, as it's faint, but you can follow the spray marks and they go into the gravel beneath where the excavation initially occurred, where they pulled out that.
I'm sorry, beneath where the excavation
initially occurred, where they pulled out the initial piece of sidewalk of concrete pavement there. And
okay,
so
nothing surprises you or makes you think something.
It's a fairly routine thing, I guess. I mean,
okay.
you like I said, I've been on a lot of these sites for a while, and so these they kind of all start to. It looks nothing out of the ordinary. I mean, you can see where they dug out the.
All right, and I just wanted to show you if I can get it to it. So, these are. So we had one more picture. Oh, here it is. All right, so this is another one. Oh, I'm sorry. So the picture I was showing you there was not what I said it was. This is actually the exhibit, the Gassner 1 exhibit. That's what we were just talking about. Sorry about that. And then the other picture, now this is attachment C to RG6. This is the one we discussed, I believe the witness Gassner discussed. Were you in attendance for that discussion? I don't.
Yes.
You were. Okay. So anything you wanted to say about this picture?
It looks like, well, from what I understand, this is right prior to the other picture being taken. It looks like they just have made an initial, looks like they've just stopped the leaking gas from the image. I mean, the blue rectangular item down there, and with the white coming out of there, that's what I would assume is a squeeze off tool is what they call it. It's just a tool they use to deform the service line so that it can no longer allow gas to move between the pipe. So they'll typically put one of those on during, if there's an accident or something, or even sometimes during routine work. If they need to stop flow of gas through a pipe, they'll use these squeeze off tools. Well, they'll just apply pressure and it'll crank down on the pipe so nothing can get through. And at that point, they'll dig other points in the wherever they deem is a good spot to cut off the pipe, put in a new one, repair it in one way or another. So I believe that's what I'm looking at here is just a squeeze off tool, not a permanent repair or anything of the sort.
I know there was some discussion about that the company had to do the permanent repair. They had excavated some more area. I think they mentioned the green area, the grass area, and then buried the pipe to appropriate depth, at least in the repair site. Does that conform to your understanding of what should happen in in a permanent repair in an emergency like this?
Yeah, so they kind of got to it too when they were explaining it in some ways or another. So what we're seeing right now is kind of step one, stop the immediate leaking gas, and so they apply that squeeze off tool, and then at that point they're gonna make determinations of, well, how deep are we right now? Are we shallow? Do we need to get below one of those requirements? Do we need to get below into 18 inches? Do we want to put it at 30 inches? What makes the most sense? What's in the ground? So they're going to need to, like they said, they're going to need to dig back into the grass area, back into to get the pipe to bend the way they want it, so that it doesn't make a sharp curve, I guess. It's I'd imagine the pipe they're using now too, it's not always it's flexible, but you can't make 90-degree turns, and even regulations don't allow you to make certain drastic turns without using some sort of fitting. So if you were to see something after this happened, you'd probably see this little excavation, this little hole turn much larger in the direction of the line so that they could turn that line into more of a U shape, a gradual U shape as it dips down to get where they need to for the cover. And then so that's one thing they could do. They might just say, well, we need to install a whole new service line across the street, so we're just going to get one of those drilling devices that I was talking about before, and maybe they'll just drill a whole new service right across the street, and maybe that whole thing right there will just get abandoned. So but what you're looking at right there does not appear to be the final what they're gonna leave in the ground, so to speak, I guess. So, but all that, it's something that the engineers at Alliant would mock up and to determine what they need.
And as someone who goes on sites and enforces the depth requirements, what would you expect Alliant Energy, Wisconsin Power Light to do in this situation in terms of repairing the pipe and laying at least a portion of it in at a particular depth? What would you expect to see them do with respect to this line?
Yeah, I would expect them to. Well, so that yellow piece of pipe that we're seeing, that can almost probably guarantee you that that's not in service anymore. That all that we can see is it's been abandoned. So the real question is, how much pipe do they need to be abandoned? Do they need to get rid of, and how much do they need to replace? So maybe they're just replacing 4 feet of length where it was damaged, and then enough to get them to drop to that 18 inches, or more common than that, you'll see them put it at 30 inches is where they tend to like to have it for depth. Or maybe they just installed a whole new line across the street. So without having more information from the engineers, it's hard to say. But what I can say is, assuming that they do everything that we see them do, that they were following their procedures and the federal and state regulations, it should be lower at this point now. So,
but as long as it's, okay, well, I'll leave it at that. And then I'm going to slide over to the next picture. I don't think we discussed this picture before. Just to the right of the one that we were discussing on the record, and this is again attachment C to RG6. Don't know if there's really that much information here. Anything in this picture that you think I should know about or comes to mind?
no, I think that's just a maybe to give a more bird's eye view of it. You can still kind of see that the hole where they would be doing, I guess to the left of the cone where the soil's been removed. You can see the kind of a little circular shadow that doesn't conform to the other shadows in there. Yeah, right where your cursor is above. So that's looks like where the hole is right there. So that's the initial hole they made to squeeze it off, I guess.
And then one more. Oh, go ahead. Anything else?
No, so I was just gonna say the other things lying around are just it looks like a miscellaneous toolbox and probably something to test that it's not leaking, just some soapy water. I would guess that's what that is.
Okay. So let me find the last picture. Yes, here. So yeah, 2 more actually. So this is the attachments A and B. I'll just start with A, and this is in RG6 attachment A. And I may need witness Gassner to chime in here if necessary, but if everyone's okay with your answers, then we can leave them at that. I guess I'm just wondering, do you have an idea what I'm looking at here? It looks like there's like a piece of pipe and these pins or stakes, but I'm not sure exactly the context or the timing of this. So, let me get your opinion of it, and then we could probably get Mr. Witness Gassner to speak on it too. But
sure.
So Your Honor, that's just abandoned conduit.
I'm sorry. I didn't hear just
That's not
just
related.
taking questions.
It's not related. Oh, I'm sorry.
Yeah, it's a question for Witness Rodriguez. So let's have him answer.
Sure. So I guess what I can say, it doesn't look like gas pipe on the surface there. So
okay. Oh, okay. So maybe just something from the construction. Okay.
correct.
All right. And then the second picture here, attachment B. Does that raise any information I should?
No, it just looks like another, if I was to, there's no visible sort of anything that would give any indication that there's gas near, looks like non-gas work.
Okay. Yeah, so I mean, I don't want to take this too far off the rails, but I do. Usually these pictures end up becoming really important when I'm looking at the record, and then I ask myself, well, I don't really have an idea of what these are. So we may have to get back to these, but let me just ask if Attorney Rogers, if you have any other questions for the witness.
No further questions, Your Honor.
Okay. So let me, let's see. Did you have any questions for, so let's have questions from the complainant, and then, we'll see where this goes. So go ahead.
Your Honor, could you put on the screen exhibit WPL Gassner 1?
Yes. I'll get to it. Yeah, hang on. It's in here.
Oh,
Yep,
and that
it's-
was
Yeah, okay, I'm just gonna expand it so see the relevant parts. That's good. Okay,
Mr. Rodriguez, can you hear me okay?
I can.
Okay. So in this picture, the locate begins in this photo in the foreground with a line at the curb, and then it goes across the sidewalk up to the house. Could you describe what you see where the line goes to the house?
Sure. So just going to the house, there's the locate marks, the yellow spray paint, and then it looks like there's a yellow flag back there, the little more prominent triangle, yellow triangle. And it looks like you might be able to see the meter set back there too, but it's just a gas service line, indicates a gas service line running to the house back there that would presumably attached to the main some point outside of the picture in the foreground. So across the street, more likely than not.
In your experience, does observing the meter indicate the presence of a gas service line?
Yes, so that's a telltale sign so that there's facilities around. Either that or a line marker of some sort, but that the gas meters are a big flag for gas facilities being nearby. There's, unless they had gas running through the alley, which a fairly uncommon thing, you're going to put, so it's more likely than not running through the street more often. So.
Thank you, Your Honor. That was my only question.
And just to follow up, you mentioned that it's not proper or within the regulations to bend a line very much. There's certain parameters. So would you expect service lines to generally be straight from the meter to wherever it's connecting to the main?
More often than not, that's the safe bet. I don't want to say a safe bet. That's the winning bet, but strange things happen. Like we were saying, maybe they might have to go down in depth because they might hit a boulder or a rock that sends them off the path. It might be the same case where they have to go make a drastic turn to the left or the right to avoid that. Or maybe there's some sort of sewer lateral, or there's fiber optic cables or something that they really just can't get around. So they'll have to do some strange curve that you would never guess without having locates called in and being able to see where these lines actually are. So that's. Yeah.
But seeing the meter and seeing the street, you would generally say there's going to be a facility in that area somewhere.
That is correct. So I mean, even if you don't see one, you should you're supposed to call. But seeing a gas meter without any lines indicated, it's a red flag, so to speak. So that you should, yeah.
Okay. All right. So no other questions from the complainant. How about Mr. Lalonde? Sorry. Questions?
Yeah, Lalande's good. That's fine. It gets murdered all the time. All right. Well, thanks. Alex, were you on site when this happened?
No.
Did you see the damage or the pin in the gas service?
I did not. I did not respond to this.
Did you see a section of pipe that they would have kept? That they would? You said they section it. Do you know of the existence of that section of pipe? And is it still? Does the utility still have it, or does PSC have it?
It's a compound question. Can we separate out those questions, please?
Did you inspect the pipe that was damaged?
I did not inspect the pipe that was damaged.
You stated that lines will move up and down in the ground. You said compaction and stuff like that. In this area, is it possible that with that compacting moving up and down, a line could actually spring a leak?
So I guess it depends on the type of pipe. Some older pipe, cast iron, some materials actually are prone to, over time in different environments, they will suddenly spring leak, so to speak. That movement of frost and whatnot is often a case that'll cause that. We don't actually have cast iron mains and whatnot in the state of Wisconsin, but there are certain materials that are leak prone, so to speak, is the term that they're given. Certain vintages of pipe, and they'll typically, if they're going to leak, it'll be at connections to other fittings. So oftentimes at the connection to a main, where you'll have one pipeline branching off, the service line branching off from the main. There'll be a little, they call it a T, and it does make a T where it'll the service line will be on top. And so if it's one of these leak prone pipes, and the soil's moving from frost heaving, it's not uncommon for these things to leak at those joints. That being said, the pipe in question, it doesn't look like one of those leak prone pipes. It's not one of those vintages from what you can tell.
Is it possible that a leak could have occurred here? In your professional opinion?
I'd say it's highly unlikely, just given the maybe if there were a lot of roots that we saw in the picture that were snaking all around it, or maybe if there was a lot of really large boulders that were uncovered there, something like that might give the indication that, okay, maybe a really large chunk of debris there settled on it. But just from the pictures that were shown, it doesn't look like there's any sort of indication of something that would be more likely to have caused the damage than the other than the ongoing construction above. So really looking at the pictures, it doesn't look like there was some sort of third party force that I would expect to be equal to or greater than in probability to have caused this to leak.
Your Honor, could you put up the picture with the clamp that he was talking about?
Sure, the emergency fix, yes.
Yeah, the emergency. I'm going to this is the first time I'm seeing these pictures. So I'm very intrigued by these and very actually pleasantly surprised that we have them.
So this is the RG6 attachment C, the picture to the left.
Alex, in that picture, do you see rocks, small rocks that are 3-4 inches in diameter?
It's hard to gauge the size, but I do see the rocks on the surface that I believe you're alluding to. Okay,
thank you. And prior testimony puts this in the right of way. Do you agree to that?
Could you say that one more time?
Objection. Mischaracterizes prior testimony. Doesn't refer to specifically what testimony.
Would you testify?
Okay.
Would you
I'm sorry, I didn't hear. Excuse
me.
Excuse me, I didn't hear the end of what you said, Mr. Ramirez. Doesn't refer to specifically what testimony.
What testimony Mr. Lalonde is referring to?
Thank you.
I'm sorry, I'm on a delay here. So is this kit in the right of way?
Again, it's I don't know that without any other knowledge. That's not some knowledge that I'm privy to.
Do you know the definition of right of way?
Objection, argumentative question. Judge, I believe that this line of questioning assumes facts not in evidence. We haven't established that right away in this case.
Okay, well, I can say, I think in a more overarching ruling that right of way is really not an issue in terms of how we handle this. That's not really a legal parameter in whether there's a violation or not. So it really, it's irrelevant whether it was in the right of way or not in the right of way. So if there's a different question, or if you're, leading up to something, let's ask that question, because whether it's in a right of way or not, I don't think pertains to the violation that's being alleged.
It pertains to the responsibilities. That's how it pertains. And the witness testified that it has to be 18 inches in the right of way. When we see here, if you could put up the picture, Your Honor, of the forms, where it's just flat and graded with just the forms, please.
So I think that's the picture to the right oh, I know what you're talking about. Okay. So
It's the one where it's all ready for concrete. Nope, next one.
It's just not easy to find. Hang on.
Yeah, like I said, this is the first time I'm seeing these.
Okay, so this
Right
is
there.
RJ6 attachment B, shows the form and okay.
Okay. Mr. Rodriguez, you talked about when lines are severed or hit, you'll see the blowing. This is prior to them digging or anything. Do you see any disruption in the ground that would cause you to think that there's a damaged pipe there?
From this picture, I would not be able to make any call on that, especially given the pressures that we're dealing with the lines.
Okay, when you're dealing with hits, is it common that the fire department or the responding utility uses a gas meter to find where the leak is?
Objection, I'm not sure that my witness is prepared to speak as to the practices of a fire department. That's not quite what we do at the commission.
Okay, I can sustain that.
I'll rephrase it.
Okay, go ahead.
In your work, do utilities typically use a meter to locate a leak, or excuse, not a leak, but a damaged pipe?
Again, I'm
Or
gonna.
is it evident?
I think this might be better suited for a different witness. I'm not sure it's appropriate to be asking Mr. Rodriguez what.
Well, he's the expert that says that he knows what a leaky line looks like, and I'm asking him. This is prior to anyone doing any work. They just came up on the scene, and is there typically when there's a gas rupture, it's blowing. He was saying it's under like a tire pressure, and it would be blowing material. It would displace material. Do you see any displaced material here?
Asked and answered, Your Honor.
Yes, okay, you did answer that already. That's true. So
my last question is how often do you deal with your expert witness today? How often do you do expert witness? And how often let me rephrase that. How often do you see shallow pipes being hit? Hotline or not hotline, just in general.
I'm just going to object for vagueness. I'm not understanding what. I'm not understanding the context of the question. Is it Mr. Lalonde? Are you asking? Well, I'm not sure if Mr. Lalonde is asking about Mr. Rodriguez's experience as an expert witness in pipeline in PLI in this type of investigation, or can you please clarify?
Yeah,
Well, he's a professional, and we're using his experience,
Mhm.
and he's got experience, and you brought him up as the expert. So, as an expert, do you see shallow pipes getting hit more than deep pipes?
You just need to define shallow for us. If you're talking about pipes sunk less than 12 inches, or
Yeah,
just
I
give
would
us a
say
number. Mhm.
Pipes that are not at the standard depth of 18 inches in the right of way and 12 inches on the private. Do you see those the pipes that are above that, standardized and a standard depth? Do you see those getting damaged more often?
Can I go ahead and answer some?
Go ahead.
You're breaking up a little.
So I guess the answer to the question can vary a little bit based on, are we speaking high level national state incident trends? Or are we speaking just things that I've seen personally firsthand?
He asked
or are
what
we
you.
talking
He asked your experience, so your.
okay, firsthand?
Mhm.
It's not often that I'll go to, this isn't an everyday occurrence, so the sample size is a little small for that. So just to, I guess, give a little disclaimer, but that I they always have to point to a root cause when they do investigations on these sorts of damages, and depth isn't really something that they point to as one of those factors, really. So it's not something that I haven't seen systemic issues with depths causing damages. But did I get to your question, I guess?
Yeah, it's fine, Alex. It's fine. No further questions. I think I made the points, and thank you for your time.
All right, thanks. Yeah, we have Mr. Or Witness Gassner with us here. Because you guys had filed these pictures, are these pictures ones that Witness Gassner took? The ones in RG6 attachment A and B?
We'll refer the question to the witness. I think we might need to go picture by picture. Well, I'll let the witness answer. I
Right,
have my own understanding, but let me let the witness.
Sure, yeah. So, yeah, just because I just wanted to know what we're looking at. So if you, well, let me say, I guess it doesn't mean, well, you were on the scene during the repair. Is that right, Witness Gassner?
Yes.
So you can describe what is being portrayed by this attachment A? You feel qualified to do that? Whether you took the picture or not, I guess is what I'm asking.
Yes, I took beforehand pictures, and this would be one of them.
Okay, so this is a beforehand picture. I think the way the cone is being shown, this looks like, let me make a guess, looking out to the street. Is that true?
No, it's looking in.
Of course. Thanks. It's looking into towards the house from the street. Okay. And so if I'm going to look at this picture and say this is going to show me something about what happened here, what is that? How should I complete that sentence? What's happening in this picture?
Your Honor, just because the witness has filed written testimony directly on the point you're asking about, could we start by referring there? And then if you have further questions, so I would refer, Your Honor, to his direct testimony, Gassner 2, and beginning on page 2, line 19 through page 3, line 19.
Okay.
Then he does a little bit of a walkthrough of the photos and what they mean.
All right, I'll just take a minute off the record. Let me review that. Thanks. Okay, so maybe after reading that, maybe I have just a few specific questions. So this picture, attachment A, where's the third pin that you talk about in your testimony?
If you would look in the, like, next to that orange cone, and be towards the house side, you see that one pin that's it's at an angle. I don't know if you can see that in the corner of the form in the sidewalk.
Yes.
If you count over to the third one, that's where I'm getting the third pin.
Okay. And then what kind of looks like a stick, maybe this long item that's in the foreground in front of the sidewalk form. Can you tell me what that was?
Honestly, I don't recall that. I don't recall what that would be, but it was nothing to do with our utility.
Okay, yeah. Do you recall how much height was left on that third pin that we just identified? How much pin is sticking out of the ground? In inches?
Judging by the picture, maybe 4 to 5.
Okay, and that doesn't include the amount that may be covered up with the form that's in front of it?
Just for clarity on it, this is attachment A.
Yeah.
Attachment B may also be helpful because attachment B was somewhat how Mr. Gassner's testimony was oriented.
Okay. All right, yeah, it's a little bit harder to see. Okay. Right, so so if you're looking at attachment B, if you're judging from the picture, I guess I can do that too, but if you're judging from what you saw on scene, can you give us the depth, what's exposed in terms of that pin from the ground up? How long do you think that is?
I'm not sure what you're asking. How long do you think I think that third pin is? Or
Coming out of the ground, yeah.
again, I would say maybe from there, I guess, on the backside.
Mm-hmm. Mm-hmm.
I think Mike said that the forms are 3.5 or 4 inches. So
4 inches.
4 inches, so maybe 7 to 8 inches altogether sticking out of the ground.
Okay. All right. Good. Thanks. Kind of the ballpark. I understand it's not very precise, and we may never know at this point because we can't really get a precise answer. So that's fine. Okay. And then did you want to comment on any other pictures that you didn't talk about before? Just wanted to give you the chance to do that since kind of the first time we brought some of those up. So there was,
Nope.
I guess yeah, okay, that's fine. All right. Any questions
Your Honor?
Yeah.
Your Honor, could you ask the witness, was there a noticeable hiss or displacement of material from the gas?
Yeah, so
Your Honor.
Yeah, go ahead.
So one, Mr. Gassner.
Wait,
already
so
spoke.
who's talking? I can't
This
see
is
anything.
This is
Oh, the thing is in your face, so I
Oh, there
couldn't
we go.
tell. That's
Sorry about
okay.
that.
That's okay.
There we go.
All right.
Mr. Gassner, so I guess I would say the reason why I'm speaking is I have an objection to asked and answered.
Yes.
Mr. Gassner already described his observations on the site
Yes.
in his direct, and then he was already subject to cross-examination once.
Yes, I agree. That's
That's
fine.
fine.
That's already
That's fine.
Okay. All right. So any questions on redirect we need to address for Gassner? No? Okay, great. All right, so we got all those pictures covered. So we had did Wisconsin Power and Light have the opportunity to cross witness Rodriguez?
Yes, Your Honor.
Okay, can't remember. All right, good. So everyone's been crossed, and is the witness ready to be excused? I actually, to be honest with you, I just don't know at this point. I don't know where we are anymore. So, are we?
I think that Mr. Rodriguez is still technically on the stand, and I
Yes,
don't have
that's
any
right.
further, I don't have any redirect for him.
No redirect. Okay, that's the question I needed. All right. So you're excused, witness Rodriguez. You're excused, witness Gassner. Thanks for indulging me. But to be honest with you, those pictures do come in handy. Let me ask witness Lalonde if you wanted to comment on those pictures that you didn't comment on yet. So I think there was the attachments A and B in particular. Can give you an opportunity to do that.
Oh, those pictures? Yeah, that's the first time I see them. I just say
Well, let
that
me just
they're-
remind you, you're under oath.
Sure.
Okay, great. So yeah, so I'm just showing you for the moment here, attachment A to RG6. So do you have any comment on that?
Yeah, if you look at obviously the orientation of the camera differs, but if you look at the 3 pins that are closest to us, one is, almost 2 feet out of the ground. The other 2 are, noticeably higher out of the ground, not quite 2 feet, but at least a foot. So that goes back to what I was saying earlier. That's our protocol. The second thing is we don't see any displacement in this, and it seems like we're being demonized that we left something leaking. We had no idea this was even there. We don't even know. I'm still not 100% convinced we did it. But these pictures are very helpful. I requested them back in April of 2023. This is the first time I'm actually seeing them.
Okay, Your Honor.
We don't need to go there. It's okay. It's okay. That's his statement.
Okay.
And then for attachment B, any comment you have with that? Let me get the whole thing here.
No, I mean, it looks like a great setup of some concrete forms, well graded, and the pins are, above the grade where we want them to be.
All right. Okay, so
I will make the comment, Your Honor, I will make this one comment. When they excavated to dig that, there were several rocks, large, I shouldn't say medium-sized rocks that they uncovered. And I still have yet to see a picture of the damage to the line or the pin in the line.
yes, I don't have that picture here. You're right. Okay, so I did have, I think, one more question for witness Rodriguez, if he's still available, if we could recall him.
I believe he is, Your Honor, and if
There he
I
is.
could take a moment, there might be something regarding the pin in one of the third party in the 911 report, but I would need to take a look.
Okay, well, if it's, did you have a question about that, or you just wanted to, if it's in the record, it's in the record.
Okay.
Yeah, okay. So there was some discussion about the definition of excavation in Wisconsin statute 182.017.50175.
Yep.
And I was just curious, in terms of your opinion, witness Rodriguez, and your expertise, would driving those pins meet any of the activities described in that definition of excavation, in your opinion?
Yes, I would say.
And which word would apply in terms of the description that's
Massive.
provided in the statute?
Sure, I would say specifically mass of material wrecked, moved. You're wrecking material by driving a stake in. You're moving material, you're pushing dirt, displacing it.
Okay. All right. Okay, thanks. And Okay, I think I can excuse any questions on that from anyone?
Your Honor, the word auguring in this statute is a bit of an archaic one. And I'm not sure, that it's a, technical and engineering word, but, might be relevant to the court.
Okay, well, all right, so I think we can leave that for parties to brief if they so choose as to which term applies as far as a legal definition, but I was just curious in terms of expertise if there was something descriptive in the activity that matched one of the words here. Okay, so with that, we can excuse you. Thanks for coming back. And I think we have all of our witnesses checked off and all of the documentation is received. So we can move on to post-hearing matters. Like I mentioned, I'm gonna turn the screen share off. Like I mentioned, well, first of all, we do have public comments still. We'll still accept those up until I believe it's Tuesday tomorrow of next week. And yeah, I don't see that we have any on file at this time, but still an opportunity for that to come in. In terms of the parties, we will accept, and now let's get this on the record, sorry. We will accept, we'll have a draft transcript be served to you by email in 2 days, 2 days from now, 2 working days. So that'll again be Tuesday as well. Parties can review the transcript and then file and serve any corrections that they would like me to, well, we can offer corrections that they would like me to receive for the transcript. So that would be due on Friday of next week. Then parties can object to the transcript corrections that another party is proposing. So that'd be 2 more days. So that would be the Tuesday after. That would be the objections would be due. Then I'll decide whether to accept or reject any of those proposed corrections, and you'll receive a final transcript shortly after that time frame. In the meantime, transcript corrections usually aren't that significant. We don't expect them to be very significant in the case. So in the meantime, you can use the draft transcript to produce any legal brief that you wish to file in the case. But now it's an opportunity. I'm just going to ask parties if they do wish to file the briefs in this. So I'll ask first the complainant. Do you expect to file a brief?
Yes, Your Honor.
Okay. And, this is the complaint. So we could do alternating briefs, or we could do briefs, concurring briefs. So if we did concurring briefs, how much time do you think you would need to produce a brief after the draft transcript is served?
And the draft transcript would be served Tuesday the 6th.
It would actually be Tuesday the 30th.
Tuesday the 30th. Oh, okay. Well, today's the 26th.
Right. So
And-
2 days, 2 working days.
Okay, the draft transcript, and then Your Honor, you indicated, okay, the final will be, what day would the final transcript be done?
Well, the final would come after any objections. So objections to proposed corrections would be August 6th. And you'll get the final at some point thereafter. I don't know, expect like the 8th or the 9th. Like I said, you don't necessarily need the final to start briefing.
Right.
Start your brief. So
Would Friday, August 16th be too much time?
no, that's fine with me. So that would be initial brief, and we file those at 1:30 p.m. So I'm going to ask you, the respondent, Lalonde. So we have an opportunity. I think it makes sense probably to have you file an initial brief if you're wishing to file a brief. You have an opportunity to file an initial brief as well on the 16th, where you can make your case in terms of whether the legal requirements for finding a violation were met based on the evidence that we have in front of us. Then there's an opportunity to reply to the initial brief, and we'll set that date next. So the initial brief would be on August 16th, and I can give a full 2 weeks for the reply, if that's helpful. So that'll be August 3rd.
And that's after the transcripts, Your Honor?
Say that again?
That's after we receive the transcripts?
Yeah, you'll receive the transcript next Tuesday. You'll have the draft transcript.
Okay.
And in all likelihood, it'll be very similar to the final. So you can start working on your brief using the draft.
Okay.
And then that first brief will be due August 16th. So that still gives you time, probably at least a week, to review the final transcript before the first brief is due. And then if you choose to reply to the complainant's first brief, that'll be due, the reply brief, that'll be due August 30th.
That seems reasonable.
Okay, good. And we set that time at 1:30 p.m. for the filing. All right, so we have that much. And like I said, let me review again one more time. You'll get the transcript, the draft in on Tuesday, the 30th of July. You have an opportunity to file corrections, proposed corrections, by Friday, August 2nd. And then objections to those corrections can be filed Tuesday, August 6th. And then after that, I'll decide what the final transcript is going to look like. So that's all the dates we have. And then, just so you know, I'll come up with the proposed final decision. Then there'll be an opportunity to comment from both sides on the proposed decision. And then all of it goes to the commission for final decision. So that's the basic process. Any questions left over here?
I have none.
All right. Okay, seems like Power and Light, you're okay with all that?
Yes, Your Honor.
All right, great. Okay, I think that's it. Appreciate everyone's patience, especially when I got lost a bit, I'll admit. But I think we have what we can gather in terms of the facts. These cases end up being a lot less clear than they look. So it'll take some time to sift and winnow the evidence and come up with a decision. But like I said, you'll be informed about that and have an opportunity to comment. And I'll await your briefs and take it from there. So thanks everyone for participating. I'm glad we got this opportunity to do this together. So appreciate everyone's contributions here, and take care, everyone. We're adjourned.
Thank you. Have a good weekend.
Thank you.